Jamari. Jamari was the victim of a car accident caused by a driver who was drunk and traveling at a high rate of speed. According to the investigation, immediately prior to the accident, the drunk driver was traveling at speeds between 76 and 91 miles an hour on a road where it's posted for 40 miles an hour. Jamari tragically died from the injuries that he sustained in this accident. Jamari was 18 years old. He was getting ready to go to college. He, if you remember the stories from his parents, he had a very bright future in front of him, and it was all taken away. And as we all know, this happens far too much. The drunk driver in this case was found guilty of vehicular homicide and sentenced to the maximum penalty of 10 years. As this is considered a non-violent offense, it is possible for the individual to serve about a quarter of the sentence in prison. This means that when considering the diminution credits and the possibility of parole, the offender could be released in as little as just over 2 years. I believe that this is far too short for a time for a crime of manslaughter that is caused by a vehicle or vessel. It is important to note that this bill does not impose any minimum sentences. It only gives our judges further discretion in their sentencing of those individuals who are found guilty of violating this law. I respectfully request a favorable report on Senate Bill 364. Thank you for your consideration. I'd stand for any questions.
Excellent. Questions from the committee? Well, Senator, thank you for bringing the bill back and to the family. Thank you for your presence here today. I remember the hearing vividly, and obviously we're all very sorry for your loss, and we'll look into this bill again this year, but just want to say thank you for your continued engagement and advocacy. It means a lot. If there are no questions from the committee.
I also should have, I feel terrible about this. I should have recognized our state's attorney, Jamie Sterling, yes, who was the one who prosecuted this case, who is sitting here with the family.
Excellent. Good to see you, Jamie. Welcome. All right, with that, that'll conclude the hearing for Senate Bill 364. Thank you very much. All right, Senator Bailey is now up with Senate Bill 394.
Thank you. Can I bring my panel up, my distinguished panel? Good morning, Mr. Chair and distinguished members of the committee. Senator Jack Bailey, representing St. Mary's and Calvert County, for the record. This morning, we're going to talk about Senate Bill 394, which would provide for criminal penalties for individuals who intentionally conceal the death of another. I'm joined here this morning by some state's attorneys that you all know. Jamie Sterling from St. Mary's County, Scott Schonbauer from Baltimore County. I think we also have a state's attorney that's on its way from Montgomery County. And we have a sergeant from the state police that actually has done some of these investigations and is going to give us some information. So I'm going to just give you some of the highlights of the case, and then I'm going to let the state's attorneys dive into this a little bit more in detail and answer any of your questions. Under this bill, a person may not, with the intent to conceal the death of another, knowingly and willfully dismember, destroy, remove, or otherwise obliterate by any means any portion of human remains. This bill also prohibits an individual from burying or otherwise disposing of a dead body or failing to contact law enforcement or emergency medical services if either action is done with the intent to conceal the death of another. During the interim, I heard from prosecutors in reference to this about the inadequacy of Maryland's current law regarding dismembering or concealing the bodies of those who have been the victims of violent crime. It is my understanding that the only existing law that can be applied to these circumstances is the section of the Health General article that provides for a maximum penalty of 1 year in prison or a $5,000 fine. I do not believe that this is a sufficient penalty for such a serious offense, and from my discussions with our state's attorney, the existing penalty is not a sufficient enough deterrent and is making their efforts to hold these violent criminals responsible for their actions to the fullest extent of the law more difficult. This bill also prohibits a person from aiding or abetting another who undertakes any of the actions prohibited in this section. So it not only covers the person that commits the act, but it covers the person that they called to say, you've got to help me get rid of this body. A violation would be a felony, subject up to 10 years in prison. This bill does not impose any minimum sentences, but does require that any sentence imposed under this section of law be served consecutively and not concurrently with any other sentence imposed or any other crime based on the act established by violation of this law. As I said, I'm joined by these state's attorneys. I'm going to turn this over to State's Attorney Jamie Sterling, and I respectfully request a favorable report on this bill after the hearing. Thank you. You stand right up here.
Good morning. Thank you for hearing this bill. Good morning, Honorable Chair, Honorable Vice Chair, members, distinguished members of this committee. This bill, quite honestly, frankly, came from a case stemming out of St. Mary's County for the original case. And then as I started to dive into it, I realized there are many other cases in not only my county, but several others. The case that really started this, I'm going to let Detective Schwarb go into details of that case, but even in just my tenure as the elected state's attorney in just a little over 2 years, I have seen 6 cases. Some of them were from prior instances. I think everyone knows about the Stephanie Roper case. That was a case that occurred in 1982. Stephanie Roper was a college student from Frostburg, and she was kidnapped, raped, and brutally murdered. Her hands were severed, her body was burned, and she was dumped into a swamp. In that instance, that was in 1982. That's actually the first case that really came out and created victims' rights. That was a case that happened in St. Mary's County, and that's a case that I've been working on because it has come back for a Juvenile Restoration Act hearing. I didn't think I'd be hearing so many of these dismemberment cases, but in 1995, St. Mary's also had another one. It involved a naval soldier who was at the PAX base in St. Mary's, and he shot another man with a crossbow and then dismembered his body. He scattered that body and dumped the victim body parts at the local school trash can. That was another one that was located in 1995, and that again came back for a hearing, and I handled that. In 2021, we had a double homicide involving a mother and a 6-year-old child. Those individuals were murdered, and then their bodies were completely bleached and dumped into a shallow grave. The case that happened in 2023, I'll turn over to Detective Schwartz, but there is another one that occurred in 2025 there's another one in 2025, which is right now, that I can't get into too much detail about, and that also is in St. Mary's County. It involves a 19-year-old teenager that was just located in a trash can, and again, it's a pending investigation. I can't comment on it. Why are these investigations occurring? And they make it harder. When you have a body who's not only murdered, we're trying to figure out, were they in fact murdered? What was the cause of the death? But it's very difficult to figure those things out when they're dismembered or disposed of or burned and discarded. So this bill really attacks several things. One, the murderer, him or herself, and what he or she does with that body, whether they dismember that body or dispose of it. But also there's the accessory after the fact, or the helper or the accomplice. Sometimes we know that they were part of that murder. Sometimes we think they're a part of that murder, or sometimes we have no idea whether they were. But if they in turn assist in dismembering or disposing of that body, that should in itself be a separate felony. There are other instances where we are seeing this, such as in MS-13 cases, in addition to examples of homicides happening outside of the state, New York, Delaware, Pennsylvania, and the bodies getting disposed of after dismemberment or during dismemberment into our Maryland counties. So what this bill will do is it'll address all of those scenarios. It is oftentimes difficult to go forward on these cases to even determine there was a murder. And I think that's a good segue to kind of turn it over to Detective Schwarb, because he's going to give you the example in our case in St. Mary's that just happened. But I'll also be here to answer more questions. I have many more examples from Baltimore City and other counties that they have given us as well, but I don't want to take too much of your time if you don't need any more examples. Thank you.
Good morning, Mr. Chairman and members of the Senate Judicial Proceeding Committee. My name is Sergeant Roger Schwarb with the Maryland State Police Homicide Unit. I'm here this morning to discuss a case that I investigated that led up to the introduction of this legislation. The case began on December 21st, 2022, when 50-year-old James Naborczyk was reported missing by his family at the MSP Leonardtown Barrack. The suspect, Michelina Goodwin, was his on-off girlfriend, but they were having issues at the time. They resided together along with another male roommate, Larry Murphy. Over 2 weeks of investigations, including multiple search warrants and interviews by MSP investigators, yielded a confession by Ms. Goodwin. During the interview, Ms. Goodwin claimed that on December 11th, Naborczyk was beating Murphy up and she grabbed a shotgun, which she did not know was loaded. She tripped over her dog and accidentally shot Naborczyk in the back. Mr. Murphy claimed he was outside of the residence at the time of the shooting. Goodwin confessed to dragging Naborczyk downstairs and keeping him in the laundry room for several days until he started smelling. She got nervous as people were looking for the victim. She purchased a chainsaw, and with the assistance of Murphy, a chainsaw was used to dismember Naborczyk. Parts of the body were loaded into multiple bags and chests for transportation. Portions of the body were dumped and burned in Charles County, and the remaining parts of the body were buried in St. Mary's County. Sadly, the only charge in reference to hiding, dismembering, burning, moving the body was a 1-year misdemeanor for the disposal of the body in an unauthorized location, which was meant more for cemetery personnel. Dismembering a body destroys evidence and makes recovering all of the body more difficult. The dismemberment and treatment of the body was horrific and created tremendous heartbreak and emotions for the family as the body was scavenged by animals. MSP has handled several cases, 3 just in 2024 alone, spanning across the state that would fall under this proposed bill. Thank you for your time, and I'm here to answer any questions. Thank you, sir.
Good evening. Scott Schellenberger, State's Attorney for Baltimore County. I'm sure you all missed me. It's been a little over. I'm really not going to comment on that. So I'm here in support of Senate Bill 394. We think this again is a much-needed gap filler for certain types of cases. I think it's particularly important, as our friend from the state police has indicated, when we're talking about the person who assists. You know, typically you can prosecute somebody as an accomplice to murder, but at that point they have to be a participant in the murder. When they come in after the fact and do such a terrible thing as helping the person dispose of the body, and then to be limited to a 1-year statute of sentencing really does a disservice to the type of harm that they have caused. And again, as we indicated, the Health General article only carries a 1 year. This statute carries a 10-year penalty, and it's allowed to be consecutive with any other penalties that you can get. And so the big problem is, what if you can't prove that this was a homicide? And I give the example that we had just a little while ago, in which 2 infants were found in the trunk of a car. Eventually, they were able to get, and excuse me, when I said infants, 5-year-old and 7-year-old were in the trunk of a car. They were decomposing. When they finally got down to the medical examiner's office, they were able to piece together enough to say this is a homicide, but they ruled that the manner of death was indeterminate. Now, if these had been adults, it would have been a very different situation, because they did not find a lot of damage to the bodies. And so I think this, again, fills a very important gap in our law, and I ask for a favorable report. And Ms. Sterling has a whole list of other cases if anybody wants to ask her about them. Thank you.
Thank you. So within the public defender's testimony, they state, this bill is an unfortunate step in the wrong direction, will not make Maryland safer. At its worst, SB 394 creates a 10-year statutory maximum penalty for mere negligence And if the bill passes, a prosecutor could charge someone with a felony under 10-405A1 for failing to notify police or emergency services when a friend overdoses and dies in their presence. This crime of omission lacks the actus reus normally required to accompany criminal law violations. Do you all have a rebuttal to that?
So I don't think it's just somebody who is standing by. As on page 2, large B requires a person may not aid or abet another in committing this crime. So they actually have to assist, and that requires more than proving negligence. They have to aid or abet, that means assist in committing the crime. And our friend from the Maryland State Police gave you the perfect example. There was no evidence that he participated in the murder, but he then participated in a very grievous thing by helping dismember the body. And that's what this would require. So I don't think it's mere negligence. They have to actually take part.
So then my next question, all of the examples that I heard were examples of homicides. However, on the first page on line 19, it talks about an intent to conceal the death. Death is much broader than homicide, which is much narrower, what you all are talking about. Could you help me to reconcile that?
Sure, there are instances, remember, in order for us to prove a homicide, we have to prove that someone took some action and they had committed the offense. So even if we think that, we're dealing with probable cause and proof beyond a reasonable doubt. So even if we think the person was a part of the homicide, or we have some inkling or probable cause, that's not going to be enough for us to charge someone with homicide. But sometimes, even though we think that, we can't prove that they were the murderer, but we could prove in some instances that they did dispose of the body. So sometimes this will be the only offense we can go on, but there are other instances. So I'll give you some examples that have occurred in other counties. So we think in another county there was a man and a woman, and we think, because this is what the woman told us, her husband is the one who murdered this child. So we assume we're going to believe her story. And it was 20 years later that she has kept this child's body in the freezer of her house. So we have to just assume that she was not the murderer, that her husband was. Her husband is now deceased, but either way, she cannot continue to keep that child's body in her freezer. That's an instance where we could go forward with the 10-year offense. There are many instances where we might think that someone was the murderer, but there are oftentimes, as the law requires, we must prove beyond a reasonable doubt. And even if we just have probable cause, there are times that we can't charge. We're not going to charge a case where we think that it's not going to go anywhere. These cases are extremely difficult either when they are involved with the murder or if something happens. There are instances that oftentimes sadly involve children or a older loved one. So if you're the caretaker of your parent and the parent has a fall or dies, and for whatever reason you don't call the police and you decide that you're going to bury them somewhere, or we have instances that are pending, they're putting them in like drywall, trash cans. We don't want body parts getting disposed of in that way. I think it's a deterrence in that regard, but also when someone goes missing, we're using resources, and families are thinking that this person, or having that hope that they might still be alive. Meanwhile, the body has just been disposed of. We're utilizing resources from Maryland State Police, from other sheriff's office, other police agencies, still looking for this person that has just been disposed of or dismembered. And so it does involve all other situations, not just murder.
And I appreciate you bringing that up, because the other question that I had written, which I think you touched on, but just to make certain I'm clear, what are the obligations of a person with dealing with the death of another within Maryland?
Sure, and I think this touches some of that, right? They should be contacting the police or contacting.
No, but what's the legal obligation? If I find somebody dead in the back, do I have to call the police and tell them?
Technically, no. But if you did something to conceal, and if you're doing something to dismember, I don't think there's a legal obligation per se.
If parents, if they find their child deceased, and they, under this bill, if they then bury that child, don't notify anyone, they could face 10 years in prison?
Yes, a human body, a human person is not,
They've done nothing wrong to cause the death. They've just decided, you know what, we have a yard, we're gonna bury them.
respectfully, we would want to make sure that that is in fact true. If they did in fact do nothing to cause the death, it needs to be investigated.
So
We don't want.
But is there a legal obligation for them to do anything currently under law?
I think this would create maybe perhaps that legal obligation. We don't want people to decide on their own that.
I'm not disagreeing with that. I'm
Right.
just trying to understand what your obligations are, and if there is an obligation, maybe that's something that needs to be fixed, but not necessarily criminalized. That's all I was trying to understand.
And I'll see if maybe my colleague from Baltimore County knows if there is any other legal obligation.
It's only health general.
Yeah, it's just the health general article. It's that 1-year offense, but I don't think it's statutorily required. I guess I would just hope that if anyone knew of a deceased body, that they're gonna, instead of just
Right, no, most
discard.
folk would do that, right? I
Correct.
agree with you, but thank you.
Thank you.
Chair, I'm now confused because as I read the bill, a person may not, with the intent to conceal the death of another, fail to contact emergency medical services, et cetera. So as I read this statute, that wouldn't apply to the parents who found their child dead and they buried the child unless their intent was to conceal the death. But you're saying it would.
Well,
Can you clarify?
yeah, I'm kind of reading it the same way that you are.
Okay.
Is that it's their intent to conceal the death. And so, you know, I believe the majority of state's attorneys would look at it and say, you know, are these two parents individuals who were grief-stricken and decided to bury their child, or were they trying to conceal the death for a reason? That's my thought of what the intent of the bill is.
Okay. Given the confusion, perhaps is there any other language that we might need to insert to clarify how you and I read it?
Well, I told Senator Bailey I wouldn't say this, but now that this has come up twice, we might replace the word death with the word homicide. Well, that's good when you and I are on the same page. So if you know, so a person may not, with the intent to conceal a homicide of another, fail to contact emergency medical services or law enforcement, and also knowingly and willfully dismembering the body. So, I mean, I like the statute the way it's written, but if several members are concerned, I certainly think there's language we could put together to take care of those concerns.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chairman. I had a different question, but I'm just going to follow up with that train of thought. If we changed it to homicide, I just want to make sure we don't have unintended consequences that might undermine the purpose. So I'm open. I just want to understand this. So we did that. Would it mean that the prosecutors, in other words, you could discover a body and you don't know whether it died of natural or causes or homicidal causes? So
And I understand.
Yeah.
So that's why we didn't pick the word homicide,
Right.
was because, you know, you could have, particularly in a child case,
Yes.
you could have a case where the ME is going to say, well, the child's dead, and of course, the police are going to say they were found under very crazy circumstances, like in my case, where they're found in the trunk of a car, and they're, unfortunately, I hate to say this, maggots on the body. But you might not necessarily be able to prove it was a homicide. So that's why we preferred the word death. I think that its intent is that your intent is to conceal the death, that you don't want anybody knowing about the death.
Right.
So if your child died from natural causes, respectfully, even though I feel bad for you and I feel, it's a shame, you still shouldn't conceal the death.
Because that leads to the question I was going to ask, which is, we were talking about legal obligation, and I thought in Maryland, there's an obligation, I guess maybe just the medical examiner, that any death in the state of Maryland, there has to be a determination of the cause, if possible, right? So whether you die in a hospital, you die at home.
Well, if you die in a hospital, if a doctor is able to say this person has died as a result of cancer, then you don't have to go to the MER.
I probably should have said nursing home or
Right.
home or something.
But if you die under suspicious circumstances or circumstances that a doctor can't explain, then it has to go to the medical examiner. But if you dispose of the body, just purely dispose of the body improperly, it's the health general statute.
I would just imagine there's a public policy just that we as a society want to understand, completely all deaths in the state of Maryland, because there could be information from each death that would advise us not on just criminal matters, but health matters and other matters. So
Yes.
that seems to be the public policy.
Yes.
All right, thank you, Mr. Chairman.
Mr. Chair. Mr. Schellenberger?
Yeah.
I guess you'll be, I don't know the best one to answer, but you're on the hot seat.
Okay.
So in the opposition letter by the Office of the Public Defender, they literally lead in with their first opposition is that this bill creates a new felony conviction, and that felonies are the highest level of crime. As such, that felony convictions face an increased challenge in gaining employment.
And
So-
felony convictions don't have a statute of limitations. So that family that buries that child that died under suspicious circumstances, if we don't find that body in 1 year, then we can't even do the health general article. So if you make this a misdemeanor, I got 1 year to solve this problem. And that's why we wanted to make it a felony, because you never know when you're going to find out the facts that lead you to what happened.
Thank you for driving the bus. Thank you.
Senator Bailey, I have a question for you. And please correct me if I'm wrong. In the past, have you testified about having a large Amish population in your county?
I definitely have an Amish population in my county, yes.
And if you don't know, because I don't know, you can just say so. Do you have any idea about how they deal with deaths within their community?
So I have been involved and attended many prayer services for many of my friends that were Amish. When an Amish person passes, they notify the rescue squad. The rescue squad, then they deal with it just like any other person. The bodies, based on that determination, either go to the medical examiner or not. The one nice thing that we do have with the medical examiner is because of their religious beliefs in the Amish and Mennonite community, they do work on those bodies that day so they can get them back so they are buried the next day because they're not embalmed.
Thank you. I appreciate that.
Thank you.
Any further questions? I think we're good, but I appreciate it. All right, seeing no questions, that concludes this panel. And no, yeah, the opposition was only written. Thank you so much today. Thank you, Senator Bailey. Senator Jackson, you are up for Senate Bill 424. Please feel free to come up and bring any witnesses you may have.
Thank you, Mr. Chairman. Members of the Judicial Proceedings Committee, on behalf of Senate Bill 424, for the record, I'm Senator Michael Jackson, representing District 27. My panel is joining me from the Maryland Department of Transportation. We have Assistant Secretary Joe McAndrew from the Traffic Safety Office and Deputy Chief Operations Officer Terry Seuss with SHA. Senate Bill 424 is a piece of legislation that came to me from the department. And in line with the Highway Administration's Vision Zero initiative, holds the noble aim of eliminating pedestrian and traffic highway fatalities and serious injuries. This bill is fairly straightforward. We were here last year with this piece of legislation. Senate Bill 424 authorizes the State Highway Administration to reduce the speed limit on an urban highway by up to 5 miles per hour without a traffic or engineering study. Any subsequent reductions to identical areas would then require a study. And I'll repeat that, any subsequent reductions to identical areas would then require a study. The bill applies to state-owned and maintained highways that do not restrict non-motorized access located in incorporated municipalities or locations within a U.S. Census Bureau designated urban area where pedestrian generators are present adjacent to the corridor. Presently, as you know, traffic studies are required to reduce speed limits. This often takes quite some time. And that is a hazard to our communities. No longer where the highway uses are no longer corresponding with the amount of vehicle or pedestrian traffic that they were intended to on their inception. Unfortunately, roadway designs have not changed with development trends over the last several decades, and the state has to find a better and quicker way to respond. The aim of this legislation is simply to provide MDOT, Maryland Department of Transportation, with a proactive countermeasure to improve highway safety. It's common knowledge that vehicle speed is directly related to crash severity, and this bill just aims to give MDOT another tool. With that, Mr. Chair, members of the committee, we ask for a favorable report, and I'll stand for questions, but we have two experts from Maryland Department of Transportation alongside us. So, any questions? I'll take a seat. Cool, thank you.
Good morning, Chair, Vice Chair, and members of the committee. For the record, I am Joe McAndrew, Assistant Secretary for Project Development and Delivery at the Maryland Department of Transportation. I'm here today with Terry Seuss, State Highway Administration's Deputy Chief for Operations, and she's going to support with any questions that you may have on this important bill. Thank you for allowing me the opportunity today to speak in support of Senate Bill 424, and thank you to Senator Jackson for sponsorship of this important initiative. Speed kills our most vulnerable transportation users. It's plain and simple. A pedestrian struck at 25 miles an hour has a 25% risk of serious injury or death. The risk jumps to 50% at 33 miles per hour and 75% at 41 miles per hour. According to the National Highway Traffic Safety Administration, reducing travel speeds of vehicles reduce fatalities and serious injuries, particularly for pedestrians, cyclists, and vulnerable roadway users. This is important because more than 570 fatalities on Maryland's roads occurred in 2024, and a disproportionate amount, 28%, were vulnerable roadway users. That's tragic, but let's drill further and illustrate, how that plays out in the geographic focus of this bill. Statewide, nearly 80% of the roadway fatalities occur in urban areas. A staggering 93% of all pedestrian fatalities occur in urban areas, and over 80% of all bicyclist fatalities occur in urban areas. NHTSA findings show that speeding exceeding the posted speed limits or traveling too fast for conditions was a contributing factor for nearly 1/3 of all traffic fatalities in the state. That exceeds the nationwide average of 29%. But again, let's drill in. Of roadway fatalities where speed was cited as a factor, over 80% of those crashes occurred in urban areas. These data clearly show that roadway fatalities and speeding are particularly acute in urban areas and urgently need to be addressed through all means possible, and this bill is a critical piece of that puzzle. SB 424 authorizes the State Highway Administration to expedite a limited 5-mile-per-hour reduction to posted speed limits on urban roads more quickly, saving time and taxpayer resources. Under current law, any changes to roadway speed limit reductions require SHA to complete a traffic and speed study. A typical study will take SHA approximately 3 months and upwards of $10,000. And this is an opportunity to go ahead and get a tool, as the senator said, to ultimately tackle our roadway fatalities.
Thank you. Ms. Seuss.
I'm just here to answer questions.
Oh, okay, understood. Mr. Corn, would you like to testify before we take questions?
Yeah, I would if I can.
Come on up.
Here? Okay. Thank you, Vice Chair Walt Stryker. John Corrin, Bicycle Advocates for Annapolis and Anne Arundel County, Bike AAA. But today speaking on behalf of a coalition of bicycle advocates from across the state of Maryland under the leadership of Bike Maryland. As my friend Joe McAndrew said, vulnerable road users, anyone traveling outside of a vehicle, pedestrian, cyclist, wheelchair user, motorcyclist, are especially vulnerable to people driving in vehicles. And I will say 5 words that are never true. Speed was not a factor. Speed is always a factor. And Joe gave you some of the statistics. Maryland tracks when speed is the proximate cause of a crash, but even when it's not, when the proximate cause was impairment or recklessness or carelessness or any other reason, speed is always a factor in both the likelihood of crash and the severity of either injury or worse, death. So we urge you to give SHA this tool to reduce speed and save Maryland lives. Thank you.
Thank you. We'll now move to questions. Senator Folden.
Thank you, Mr. Chair. So I don't know who wants to step up and start our dialogue, but I have several questions. One is, how long does a current traffic study take to complete? You're going to need to stand up at the podium.
For the record, I'm Terry Seuss with the State Highway Administration. A typical traffic study would take 60 to 90 days and cost between $5,000 and $10,000 to complete.
$5,000 and $10,000 to do a traffic study for somebody to sit out there and count traffic and watch the speeds?
So it's a matter of collecting data. We search the existing area. We look at the surrounding area, the speed transition areas. We review crash data. As part of that, we look at the roadway characteristics, including geometric information, the vertical curves, horizontal curves.
Is it safe to say you can track all that online? You can pull that up through a Google map?
Most of that, yes.
Yes,
So
okay.
the traffic, the crash data takes a little bit of analysis. We have to, review that. We do also like to do speed counts. So we would put out either tubes across the highway to collect traffic counts that gives us vehicle information as well as their speeds, or we have someone who would do radar.
Yeah. So is there anything that requires you to take this data, and are you currently sharing the data? Is it required for transparency to provide the data to the public?
I don't know if we were required to provide the
already know the
data.
answer.
Go ahead, sir.
The answer is no.
Okay.
So I'm probably not going to, I will just let you know, I'm probably not going to ask you too many questions I don't know the answer to, but that one's definitely no, and you don't share it. And you don't have to share it because there's no justification requirement to lower a speed limit as it's written right now. The volume, the speeds, any of that, you can, as long as you do the study by law, it doesn't require you to release the data. It just says at that point you can lower the speed limit, does it not?
You said you knew the answer, so I'm assuming you.
Well, I would like to hear you say the answer.
So apparently we don't. I would
Yes.
imagine that we,
don't.
through the
Correct.
Public Information Act,
Correct.
share that information.
So the public has to go through hoops to get this data of why you guys are lowering stuff. And then a common trend we see in some of the larger counties is we'll see them do a traffic study with zero merit to their decrease in the speed limit, but they'll do it. They'll lower it without releasing the data. And then you know what comes next? Speed cameras. So it's another way that the state has found out, and these counties have found out cleverly, that they want to get into taxpayers' pockets. Because, and you're guising this around safety, which is amazing because I'm pretty sure earlier this session, somebody came in and said that traffic fatalities in the state of Maryland are.
All right, so let's get to some questions where we actually are looking for.
I'm asking the questions, Mr. Chair. I'm not getting the answer. I'm asking her. I already know the answer, but she needs to answer my question.
Well, let's move to the sponsor. If you have questions about.
He's not going to have the answer to that. She has the answer.
I would say 2023 was one of our highest year for traffic fatalities. 2024 is looking like it has reduced, but it's still about 700 or 570 fatalities.
We're down. So you're asking for a bill after numbers have gone down. Now, I know Vision Zero, I'm familiar with that, right? I get that. But the traffic fatalities across the state are down. So, and traffic and roadways, even the ones that you're referencing in some 1974 to conform to the maximum posted speed limit, and it's always done off of roadway design and engineering, right? So roadways currently, by NHTSA standards, have to be designed and engineered to, and this includes bends in the curves, super elevation, the slope of the roads, all that, right? The runoff of the rain has to be at a certain percent, right? The drop, super elevated crowning of the road, all these things play into it, correct?
Yes, sir.
So is there any change in this that's going to change those roadway designs by, I mean, the roads are already designed to carry vehicles at a set speed, and they're safe for that by current engineering standards set by NHTSA.
It's actually the AASHTO, Council of State Governments who set those determinations. But I would say that that's based on antiquated information. I've participated in studies where we lowered speed limits on Maryland 99 in Howard County, for example. That used to be more of a rural area, farmland, that roadway geometry. I live near that area, I travel it. It was a little uncomfortable at 45 miles an hour. Since then, there's been development in that area. There are now schools along that corridor. There was a community request to lower that speed limit to 40 miles an hour. We did the traffic study. We did lower the speed to 40 miles an hour. I think one of the important things is also coordination with our local police departments to ensure that they have support for that. So I think these are very modest reductions in the speed limit that prove a safer travel speed given the context of the roadway. So again, housing, schools, businesses, those types of things, along with that there may now be vulnerable users, as Joe mentioned in his testimony. So if there's bicycles and pedestrians, we would want drivers to consider that as they travel.
Are people more thank you for that. Are people more likely to travel at the speed limit, or are they more likely to travel at the speed that they're comfortable with because they're not really looking down at their speedometer? Is that a fair statement?
Absolutely, that's a fair statement.
And then when we're talking about vulnerable road users, I keep seeing in some jurisdictions more than others, and then we passed this a couple years ago, that now we've got to add in money when we design a road, because we've got to add in ballards or whatever they are, and we got to add in widening, deeper subsurface for the riding for these bike lanes, but they've also got to be built heavy duty enough to still carry highway traffic, correct? How much of the tax or fees do bicyclists pay towards the Transportation Trust Fund for these extra lane widths that they get?
There's no revenue from bicyclists.
All right, Senator Sidnor is next.
I'm not done, Mr. Chair. I still have two more questions.
All right, let's finish up. We want to make sure everyone has an opportunity to ask questions.
I'll come back to my questions. I might have more. Thank you.
Okay, Senator Sidnor.
Thank you. And just to be clear, what are the purpose of traffic studies?
The purpose of a speed study in particular?
The studies that we're attempting to take out.
So that would be a speed study where we gather the free flow speed. So we would do it at a time where we don't do it at a morning peak hour where traffic might be more congested and traveling slower. So we're just trying to determine the average, or what we call the 85th percentile of people traveling on that roadway.
So what would we be losing by not doing these studies?
So we still have the authority to complete the study if we feel it's needed. However, with this bill, we would administratively reduce the burden. So if we have corridors that are very similar, one is posted at 30 miles an hour, and we have another roadway with very similar context, very similar traffic, very similar patterns, we could implement a lower speed limit on that second roadway to kind of match the characteristics without completing the study. So it's reducing the administrative burden.
And I was looking at the fiscal note for the definition of urban highway, and as I'm reading it, an urban highway could be four different, it lists 4 different points. Constructed with a curb and gutter and an enclosed type storm drainage system located in an urban area and on which is located a public facility that creates appreciable pedestrian traffic along the highway from adjacent areas. 3, located within urban boundaries as defined by the U.S. Census Bureau, or 4, located within the boundaries of a municipal corporation. So I'm reading those as 4 separate things as to what an urban highway is, right?
Correct.
All right, so the last question then that I have is, what is the breadth of the change when we're talking about urban highways? Because when I was reading the second page, it was talking about how unless there is a special danger that requires a lower speed, the maximum lawful speeds on the state highway, and they started talking about 15 miles per hour in the alleys in Baltimore County. But in my mind, if I'm thinking urban highways, I'm not thinking alley. So what is the breadth of this change that we're asking for?
The breadth of this changes, so urban corridors make up, we were trying to map it out this week, but it's a small percentage of the roadways within Maryland.
Would it be Route 40 or Baltimore National Pike in Baltimore County?
Yes, that would be one of them.
Security Boulevard?
Yes, sir.
Okay, thank you.
Senator James.
Thank you, and my questions are going to reflect that I'm not familiar with a little bit of this process, but currently, when SHA does come in and do an engineering and traffic study, is there an opportunity for the public to weigh in or review the process as it's ongoing before decisions are made?
Typically, the requests to lower speed limit do come from the community. Like I mentioned earlier on Maryland 99 in Howard County, that came from parents at the local high school, raised that through the county council. They brought that request to us, but we do not, as Senator Folden mentioned, share that information publicly before we do lower the speed limit.
You're trailing off, and so I couldn't hear you, and I'm also just asking as a matter of course, when SHA is doing traffic and engineering investigations, is there an opportunity for the community to weigh in or provide their opinions, feedback?
No, not as a part of our current process. We could absolutely add that into it. However, again, I think that typically the requests to lower a speed limit are generated from the community members.
I'm not tying my question to a request to lower the speed limit. I'm asking you, I mean, perhaps SHA doesn't do any traffic studies unless there's a request to lower the speed limit, but I'm guessing that SHA does conduct traffic studies and engineering studies even when they're not being asked by the public. I'm asking you a very global question.
A very global question, yes.
I don't want to make this really long, so I want to get beyond this basic question.
Absolutely. So if we do many different types of traffic studies. I was specifically speaking about speed reduction studies or speed studies, which we don't have, but we have a very healthy public information process as part of our wider broad spread projects that we deliver.
Thank you. And the reason I'm asking that is that I do have some concern that cutting this out and creating this new pathway has the potential to undercut community input that may not, of a varying position. So that's one thing. The second thing I'm a little worried about, so you just explain to me how this would work. It sounds like anybody can reach out to SHA and suggest under the concept of this bill that you lower the speed limit. And then SHA doesn't have to conduct any studies if they don't want to, right? And that's the whole point, not to do that. So I don't know how SHA makes an informed decision without some of the processes that are already in place. And you might have one or two people that feel very strongly, or even a small subset, strongly that the speed limit should be dropped, but without any analysis or community input, there'd be people that would be blindsided or not agree, and we'd be cutting them out of the process. So that's one thing. The second thing is inconsistency across the state. You go to driver's education, you're told this is the speed limit, this is the speed limit. So I'm a little worried about drivers who don't want to violate the law, but are being traveling around, constantly meeting different speed limits, and then getting ensnared in the fact that they're not aware of these because there's no consistency and consistency has an element of safety to it, right? So that's my other concern, if you'd like to speak to those two.
Sure, so I'll address the first part of the question about the process. We wouldn't negate any process. We would eliminate the need for the formal speed study. However, we would still use data and public feedback to identify the corridors which may have a speed limit reduction. We can then coordinate with local police departments. We would still review the roadway geometry and use engineering judgment on the context of that. And again, it needs to be an urban highway. And then for roadways, so that would be part of our process.
Can I just get a clarification? All that you mentioned, that's in statute. Is that what you're saying?
So the statute today just says the engineering or the speed study, which again includes putting the tubes across the road and collecting that data. We would eliminate that part of it, but we would still have a less formal process as part of this.
And is that less formal process codified? It's in law?
It is not codified in law.
So I would suggest that that might be something, if you're going to take away something, perhaps you should codify, because there's no obligation by SHA or anybody else to do what you just suggested once you take away the traffic and engineering study. Okay, go ahead. The second question?
On consistency, so again, we would use the context, and again, it has to be an urban area. We'd use that context again. Are there schools in the area? Are there places of worship? Are there businesses that people are walking to? And then again, try to very much do that in a consistent way so that corridors with consistent types of travel and consistent looks have consistent speed limits. So very much to your point.
Where's the definition of urban highways? I'm sure it's in the bill, right?
I'm told it's in the fiscal note, ma'am.
Huh?
I'm told it's in the fiscal note. The definition of urban highways is in the fiscal note.
Well, the fiscal note is not law, so there's not a definition of urban highway in the statute currently. That might be something we want to.
We will have to provide that to you. I don't have it on hand.
Thank you, Mr. Chairman. Thank you.
He can go before me. I've already had my.
Thank you, Mr. Chairman. So let's say this committee gives you approval for this, and it does pass, and it becomes law. And we've decided that maybe lowering the speed limit on said roadway is not correct, and we need to raise it. Can you explain to me the process?
It would be the same process. It would be, so this is just setting or allowing us to reduce.
Well, I understand that, but
yes.
what would happen if we want to raise it 5 or 10
That actually was an example of one of the speed studies we've done in the last 5 years. Most of them are to reduce speed limits, but we did actually have one that was to raise the speed limit.
Right.
Because we didn't have the appropriate transition areas. We did raise the speed limit with one of our studies.
Okay, but I apologize for my inability to understand. Would it be the same bar of the same expectations, meaning we don't have to do a study? And we don't have to turn the information over to the public?
So yes, sir, I believe it would be the exact same process.
It would be the exact same process. Okay. All right, thank you.
The way this bill is crafted, would this bill require a community ask to change the speed limit?
The way the bill, I can see how that may not be clarified in the bill. However, that would be our expectation, that there would be either community feedback through some of our processes, like we do a vulnerable users review every 3 years. That involves much public feedback on what corridors we should be looking at, or this is a request from the community.
But that is not required. This could be just a bureaucratic process of someone that says, I think I want to lower the speed limit, and then there's nothing in here that prohibits them from putting speed cameras subsequent to that. Not even anything that says they can't put them there within a year. They can't put them there within any of that. This is literally giving bureaucratic autonomy to people without a process that's been vetted, without justification, other than that's what they feel. Is that correct?
So that's certainly not our intent. Our intent is for safety and compliance with the speed limits. The current practice right now with lowering a speed limit is to allow that to kind of take effect for about a 6-month period before we take any other actions, such as placing a speed camera. So we would expect.
There's nothing in this bill that references that.
We would have to review the language. We're happy to further discuss.
And then the reduction of the 5 miles per hour, are you familiar with the time distance analysis of what that actually, the difference of that is? It's in feet.
Well, I don't have it off the top of my head, but yes, I understand.
7.45 feet per second. So you're changing someone at 5 miles per hour, you're changing that variance about 7.5, an additional 7.45 feet per second. Is current law already say that in residential districts, when we teach driver's ed to kids, it was a point that was kind of started but then didn't finish, but when we teach driver's ed to kids for statewide enforcement, what is the speed limit in law right now that we teach that the speed limit is, even without a posted sign, in a residential district?
I do not know what's in the.
It's 25 miles per hour.
Okay.
Do you know what the speed limit is, the minimum posted speed limit for business and residential districts that you can post?
I believe it's 25 miles.
It's 30 miles per hour. So these are things that are taught in driver's ed, and now we're looking to change this because this bill would allow them to take those because it doesn't have any carve out to say it can't be any slower. You know, you could take it down to 20 miles per hour in some of these areas, could you not, by the way this is written?
Thank you. So the way that the bill is written and the way that we understand it is that we could remove or reduce the speed by 5 miles an hour before you'd have to do any further studies, full traffic impact study to go any further.
Which would take it below what's already taught and is in law about business and residential districts.
Right. So I think what's important to note is that what we're trying to do here is context matters, right? And so when we've got a condition with which speed is a prevailing issue where fatalities are happening, we would use our best practices, engineering judgment, and do our best to partner with the communities which we serve to communicate what we're doing. Ultimately,
is that a requirement?
As you have said, sir, that is not a requirement. I think that's an opportunity for further discussion. But I think it is our aim that we are trying to get a tool in the toolkit to save lives.
We can say that all we want, but the tool in the toolkit that you're asking kind of goes against the grain of what a proper procedure and process, and you already have a process in place, do you not, to lower a speed limit, and you can go below 5 miles an hour more? Could you not, under the current format that you have? Yes.
Yep.
Yes. One last question I have, Mr. Chair. So you brought up the data of fatalities.
Yep.
That's what we're around. Safety, safety, fatalities, fatalities. What percent in these urban areas occurred on state routes and rural areas? What percent occurred on state routes in this state this past year? And what occurred on routes that are not state routes?
I think we're going to need to drill into the information. We can get back to you with it. But in terms of where the fatalities are happening, they're predominantly happening in urban areas. And the fatality rate for those folks that are outside of a vehicle are predominantly happening in urban areas as well. When you drill in and you look at speed being a contributing factor, right, there's many factors that oftentimes might come into fact. But in those urban areas, 80% of fatalities are associated, has a contributing factor of speed when a death happens on our roads.
We have the contributing factor of speed, but there's also contributory negligence or contributing factors of those vulnerable users that feel they have an entitlement to the road that they can get across, and that a 3,500-pound projectile traveling down the road should be able to stop and recognize them. Is that not correct?
You know, so what we're trying to do is limit the risk that we have on our roadways. Right?
I understand that, and we can
speed
do our
is
best.
a contributing risk. Roughly one third of fatalities in our state has speed as a contributing factor.
What's the other 2/3?
Driving while drunk and distraction, I think, are the other two that are roughly about the same.
Okay, thank you.
Yep.
All right. Thank you very much. Further questions from the committee? Thank you all very much. Thank you. Senator, thank you. All right. We'll now move on to Senator McKay with Senate Bill 421.
Good morning, Mr. Chair, Mr. Vice Chair, family of the JPR Committee. You know, one can judge a society, culture, and country by the way people take care of their cemeteries and burial places. I Googled that, and that came from our founding father, Benjamin Franklin. But you know, our burial sites are irreplaceable cultural sites that allow us to communicate with our heritage. There are frequently and serious threats than other cultural sites because of the lack of understanding and their importance, but more especially their uniqueness. In Maryland today, grave markers and funeral objects in many old cemeteries have been either damaged, destroyed, or removed illegally. For those who desecrate or illegally disturb burial sites, are rarely prosecuted under the law. Currently, Maryland law notes that the statute of limitations period starts when the violation is committed, not when it is discovered. That's per an AG opinion, which is in your testimony, dated June 28th, 2023. Now, Senate Bill 421 will extend the statute of limitations for prosecutions from 1 to 3 years. Since most cemeteries are not visited daily but yearly by loved ones during a memorial, it is a reasonable change that the start date be changed to when it is discovered. The bill also prohibits people from willingly destroying, damaging, defacing, and removing landscaping as part of the grounds of a cemetery. This is an addition to the current statute. Now, while I do not know why it was omitted in the past, I ask you to consider that it is understandable that the beautification around the markers should also be protected as well. Quoting one of the greatest writers in English language, Sir William Shakespeare, "Bless anyone who preserves the stones. Curse anyone who moves the bones." Let's pass Senate Bill 421 because it is protecting cemeteries, communities that uphold their past, maintaining the respect of the dead, and preserving meaningful spaces for future generations. To add a little humor, I have notes here that says, "Exit stage left, lights fade to black, and the curtain falls." Thank you for this opportunity, Mr. Chairman.
Bill Bryson would be proud of you for your rendition of Shakespeare. All right. Questions from the committee. Senator James.
I want to thank you for bringing this bill. I almost can't speak about this, so I'll be very quick. I tried to visit my parents and brother and several hundred years of family members, only to find the area completely knocked over and flowers and shrubberies destroyed. And it was just so upsetting, I can't even tell you, right? You just fall to your knees when you see that kind of desecration of what's all holy for you, sacred to you. So, and when I was able to talk to the church and the cemetery, what had happened, when the church was first built, it was in a bucolic country, relatively small area, and over the many, many decades, we're going back, it was built up, and then people came in that were not respectful of these places, and they're having a terrible time. And I know that they were utterly frustrated, and anything, they said, just anything you can do to me, anything you can do to help us, including security cameras and more law enforcement investigations. But this would go to part of that, at least give people more time, because what they told me is a lot of times they can catch people, but it takes a certain amount of time. And you're right. I was the first one to bring it to their attention, and I was doing my annual visit. So I think you really do understand the problem, and I appreciate your thinking about it and putting this bill in.
Thank you. Thank you, Senator.
Thank you. The question I have centers on page 2, line 24, and trying to understand what is contemplated in landscaping or part of the grounds of a cemetery.
So I believe in the fiscal note, it explains a little bit more of the landscaping. So if it is on the grounds, so it does need to be part of the cemetery, or in this case, family plot. And so it can be the shrubberies, it can be anything that has been to preserve and to adorn the said burial plot.
And the reason I'm asking, I'm trying to see if there's a distinction between Roman numeral 2 and what is included in that, because you have ornamentation of a cemetery is already there. So I'm trying to think what else would there be and what is it that we're trying to capture.
In subsection 2, it's looking at removing of a tree, the plant, and the shrub. So that would not be the ornamentation of it.
No, I'm on line 23.
To line 23? Page 2?
Yes, sir. It would read, a person may not willfully destroy or damage, deface, or remove a building, wall, fence, railing, or other work for the use, protection, or ornamentation of a cemetery. I think, you know what? I'm thinking I may have answered my own question. But with landscaping, I mean, I mean, I'm thinking flower pots and things. I mean, that's. I guess that's what I'm just trying to make certain I'm understanding what it is that we're trying to protect.
We are trying to protect
The thing
shrubbery, pots,
that
those
you're
type of
putting
things
down.
that have been added in addition to add to the beautification of it. But it does have to be on the ground, so it can't be something that is adjacent. So a lot of times in Garrett County, we have family plots. Sometimes they'll put fencing around it to actually, to distinguish where it exactly is.
Gotcha.
So anything within that border that is placed there for that.
Thank you.
All right, Senator, thank you very much. Thank you for bringing the bill. That'll conclude the testimony for the proponents of the bill. We have one person signed up in opposition, David Zinner. Mr. Zinner, welcome.
Thank you, Mr. Chair, Mr. Vice Chair. My name is David Zinner. I'm the coordinator for the Maryland Cemetery Legislative Advocates. This is a brand-new group of 12 people who have extensive experience with cemetery issues. We've been working on doing cemetery legislation for the past 6 months, and we think we've got some really good bills. I'm also a consumer representative on Maryland's Advisory Council on Cemetery Operations, but not representing the Council of the Office of Cemetery Oversight. Our group believes a much stronger bill is needed. We appreciate Senator McKay introducing this bill, but we think when we look at examples of desecration, we're not only seeing things like swastikas on tombstones and tombstones turned over, but we're seeing issues where bodies actually are being dug up and moved in a cemetery. One example in the Rosa Bonheur Cemetery in Howard County, which had lots of publicity, where the developer next door, we believe, dug up human bodies and removed them without permitting from the state's attorney. We're going to be proposing a bill that will be going through the House and hopefully coming here for much stronger penalties. We're going to be suggesting possible felonies because the statute of limitations should not be on these kinds of desecrations, but also because we want the police to take these violations more seriously. And when we report a misdemeanor, often it doesn't get the same kind of attention. So we look forward to working with Senator McKay and hopefully getting a stronger bill. It's not that we oppose this concept, but we think it needs to be made much stronger. And I'd be glad to take questions.
All right, questions from the committee? We'll add a little levity to the situation with a bad dad joke. So Senator McKay, when you die, what part of you dies last?
Sir, I don't know.
Your eyes, they dilate. Oof, 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 that was bad. Bad dad joke there, all right.
That was good. It was good, thank you.
That was a, come on, man.
Mr. Chairman, I don't want to take away from the humor and, but the bill that the gentleman was talking about, you will hear at a later. I am the sponsor for that.
Okay.
I do believe that they are, while the subject is the same, I do believe that they handle two different issues, and we'll be definitely having that conversation in the future.
Great, excellent.
Thank you.
Well, thanks. I'm sure we can do something on this between the two bills, so thank you very much for your testimony, Mr. Zimmer. And you got a really bad dad joke out of it as well, so there you go. All right. With that, that'll conclude the hearing for Senate Bill 421. We'll now move on to Senate Bill 392. Senator Waldstreicher.
Thank you, Mr. Chairman, members of the committee. I cannot compete with Shakespeare, but I can tell you as it relates to this bill, my own Shakespearean tragedy. When I was a rising 11th grader, I couldn't drive yet. I have a late birthday, December 31st, and back then the cutoff was January 1st. So I was the last person in my class to be able to drive. So when I went to work each day that summer, I worked at a summer camp in Kemp Mill in Silver Spring. I rode my Schwinn every day to work and did so on the sidewalk. And the reason was because I was an inexperienced rider. I was 15 years old. I don't even think we wore helmets back then. And I wasn't going to ride on a major state highway in order to get to work. I rode on the sidewalk. And back then, I was almost certainly in breach of the law. The default in Maryland and in our counties and municipalities is that bikes are not allowed on sidewalks. The bill in front of us simply changes that default without undoing local control. It changes the default to allow bicycles on sidewalks. If our counties or municipalities want to find otherwise, they have the ability to do so. This just changes where we start. Last year, we made really good progress on this bill. It passed the House. I think it was moving here and we just ran out of time. There were some questions about who has the right of way on sidewalks when bicycles are allowed there. And so this bill also has a portion that makes clear that pedestrians and people with mobility devices because of their disabilities, electric wheelchairs in other words, have the right of way on sidewalks. With that, Mr. Chairman, I would ask that our committee for a favorable report.
Thank you, Chair Smith, Vice Chair Wald-Streicher, for bringing this bill. John Corrin, Bicycle Advocates for Annapolis and Anne Arundel County, but again, speaking on behalf of a coalition of bike advocates from the far western Maryland to the Eastern Shore. I'm very happy to see my own Senator, Shanika Henson, join JPR, and also very happy to see Senator Love, who we worked with quite a bit on road safety in the past years at ENT. If only we had safe, separated infrastructure everywhere, people from children to adults, people who have a choice to drive or ride, people who have no choice but to use a bike for economic reasons, for legal reasons. If only we had safe, separated infrastructure, they would, as in the Netherlands, they would use it. But typically, to get from point A to point B, a cyclist is only going to do it, or is going to find the safest place, as Senator Wald-Streicher did as a teen. This bill will allow the local jurisdictions to make their own decisions. Many have already. Montgomery County, Howard County, Anne Arundel County have already allowed this. Many cities have already allowed it. Some allow it in certain areas and not in others. For example, City of Frederick allows it, but not in certain congested downtown areas. Howard County allows it, but not in downtown Ellicott City. Cities and counties would still be empowered to make their own choices about where this is permitted and where it might not be permitted, either by location, by device, or even age. And some of the smaller towns in Maryland have already set ordinances like that. It has passed the House with all but 2 votes in the past 2 years, and we hope JPR will find a favorable opinion and get it through the Senate and over the goal line this year. Thank you.
Thank you both for bringing the bill, but I have a couple of questions. It sounds like what you've said, and it rings true to me, each jurisdiction and town can do this already. So why do we need this bill?
It will bring Maryland into alignment with the majority of other states across the country and set sort of a more consistent allowed use rather than being silent on it and allowing the default to prohibit. So they still, again, have full authority to make local decisions based upon local knowledge.
And then what I've got to figure out is just operationally. So just in my county and my own hometown, what they do is on areas they allowing bikes, they're very explicit, right? And in other areas they say it's not allowed. What I'm trying to figure out is operationally how this would work, because let's say a county or a town only wants bicycles to be in a very limited, thought out, but limited area. And they also don't want to have gotcha government where people get surprised and in trouble. I'm just trying to figure out how they would work through this. So the default is you can bike everywhere, and that would mean the town of Haverty Grace would have to go all over the town. First, they'd have to pass an ordinance that specified all the areas where this wasn't going to be okay. Like, you can't do it on this street in these 5 blocks. You can't. can't do over here. And then to be fair to our constituents, they should have signage everywhere. So I have a little, not so much with the intent, but the application of it and how it would work and whether it's an unfunded mandated on towns and local governments. And I'm also, don't feel like this is a huge problem, and I don't want to impose obligations on jurisdictions when they have the authority, and you can work with each jurisdiction individually, as opposed to us regulating on high down here. You know, let's try to be more thoughtful about it and work individually with jurisdictions in town. So you're welcome to respond to that.
Thank you. Yeah, first of all, Senator Delaney, thanks for bringing up the I'm sorry, thanks for bringing up the pretext issue, because this should not be a pretext for pulling someone over or citing somebody for safely riding a bike on a sidewalk. So I appreciate that you raised that issue. It would be left to the jurisdiction to decide how they want to let the public know about this. It can be done by posting on website, by promotional campaigns. They have the authority, if they want, to provide signage, but that would be entirely within their discretion. So I think there's no fiscal implication of you must put signs up everywhere. Honestly, I think that's a bit unwieldy.
I think my bigger point is this: the default now is ride your bike anywhere, and towns have actually done it a different way by affirmatively letting you know. So now they have to go out and, I guess, for safety and for otherwise, put signage where, because the default is you can bike everywhere, then the town's got to meet and carve out all the places where that's not going to be their default position. That's how right? That's what they'd have to do to follow this, right?
Yes, if they decide, like Anne Arundel County, Howard, and Montgomery, I think, allow everywhere with the one exception, downtown Ellicott City.
And that's why it's so great to let your own county figure it out.
Make the decisions,
right?
Yeah. And then I think it's the same. And then I think it's the same local discretion to decide how best to let the public know.
All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. Senator? So my position's still the same. I don't think this is the way to go. I do appreciate you trying to address a little bit more when it comes to pedestrians and that kind of stuff. And while it is the default right now, for jurisdictions such as mine, where I have such a high percentage of elderly population, why would we not just allow it to be there? And if there is enough interest to change it, the localities are allowed to do that now anyhow. So I don't really understand why it is so necessary that we change the default.
Yeah, I think that's a legitimate question. That's kind of the core question in front of us. And I think the answer kind of philosophically is it creates an opportunity to have that conversation. And so I think the idea behind the bill is we want our local jurisdictions to begin the conversation about where this is appropriate and where it's inappropriate. And by changing the default, we're saying, hey, let's begin that conversation. And if your jurisdiction, either because of a higher elderly population or because it's more rural, says we want to ban bicycles on sidewalks for the entirety of that jurisdiction, they are able to do so under the bill. It's just that conversation occurs.
Okay. The other question that I have is, as I look at the committee testimony, MACO or MML has not weighed in on this. Have they weighed in the years past?
I don't recall what happened in years past.
Okay. So this is just an observation. Well, it remains silent. Seems to me say that this isn't an issue and we don't really need, but that's my opinion.
Yeah, we can ask them both publicly and offline.
Thank you for bringing the bill, sir.
Thank you.
Thank you very much. All right, keeping with the levity, I've got two questions. One question for you. All right, which state has the most streets?
I don't know, Mr. Chairman.
Rhode Island. All right, and the bike advocate will love this one. All right, so every morning I get hit by the same bicycle. It's a vicious cycle. All right, all right.
I like
All right.
JPR on Fridays. JPR on Fridays is
They're
different.
not getting any better as the time goes on, but they're getting worse. All right. All right. With that, that'll end the hearing for Senator Waldstreicher and Senate Bill 392. We'll now move on to Senate Bill 381 with Senator Love.
I never expected to hear dad humor in JPR, least of all from the chair, but thank you.
Hey,
I arguably am the oldest in the room. Thank you.
We aim to please here, all right? We aim to please. All right. Senator Love, would you like to bring up a panel?
I would, please, sir.
Come on up.
And we have one witness who is virtual.
Excellent.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of JPR. For the record, I am Sarah Love, here to present to you SB 381, Motor Vehicles, Automated Enforcement Programs, Privacy Protections. So right now in Maryland, we have quite a number of automated enforcement programs. We have school bus cameras, we have red light cameras, we have speed cameras in school zones, in work zones, in residential zones, on certain roads such as Maryland 210, I-83, Jessup Road, Oxford Road, and on and on. We have vehicle height monitoring cameras. We have railroad grade crossing cameras. We have cameras on buses in dedicated bus lanes. We allow cameras on stop signs in school zones in Prince George's counties. Montgomery County and Prince George's County are authorized to use noise cameras. This year already, we've heard two bills, either adding or extending the use of cameras. We have, I think we found at least 7 that have been filed on this topic alone. You know what we don't have? Statewide standards on the use, access, retention, and destruction of all of that data that has been being collected on our Maryland residents. So that is what SB 381 would do. It says who can access this data, how it is held, how it is secured, how long it is held for, and what it is used for. This bill passed out of the House last year and came over, and we had some very robust discussions, and I'm looking forward to that again. But there are a couple of things I want to address in particular with respect to the opposition. So I'm going to be honest, I'm a little disappointed that there is still opposition. During last session, I met with the chiefs and sheriffs, listened to their concern, added language, was told that's great. Oh wait, no, it's really not, just kidding. Added more language, was told that's great. Oh wait, no, just kidding. Met with them over the interim, reached out to them multiple times, got some language from them, adopted a bunch of their language, and they're still opposed. Their opposition can be broken down into 3 buckets. One is, it's our data, we should be able to use it however we see fit. 2 is that right now, the retention is 6 months. Let's see, where's the exact language? Or until the conclusion of any criminal investigation or, well, I'll get to that in a minute. Their opposition is that the retention is 6 months. And their final point is that you are in public, so you have no expectation of privacy. So let me start at the top, which is this is our data and we should use it as we see fit. This data is data that is collected pursuant to a particular program. This is speed camera data. This is red light camera data. This is not surveillance data. There need to be some parameters. The public needs to be able to trust that we are not conducting mass surveillance on our citizens. That is the way our system has to work. Citizens need to be able to trust that when we say this is a speed camera, that is what it is. In addition, we have put language in here that would enable law enforcement to access that data when they need to, either in exigent circumstances or with a subpoena or a court order when they need it to conduct their investigations. And I have a technical expert here. He is here only to testify about how Montgomery County does it, so please don't ask him anything beyond that very narrow focus. So there already is a jurisdiction, the largest jurisdiction that has probably the most cameras in our state. Our law enforcement already gets a subpoena. So this is doable. It is something that I think we need to adopt. With respect to the 6-month retention, the language of the bill says up to 6 months or until the conclusion of any criminal investigation or criminal or civil court action involving the recorded image or associated data. So we're leaving it for 6 months, but if you are working on that data, it can be kept longer. And then the last piece I want to touch on is this argument that you have no expectation of privacy in public, therefore we should be able to take these images and keep them and use them however we want. That is simply a straw man and also false. You do have an expectation of privacy in certain public places. You know, if you're alone in a park, you have an expectation of privacy with a conversation that you're having with somebody next to you. There are instances when you have expectation of privacy in your own car. So as a blanket statement, that is just wrong. But the whole concept that we should be able to collect and maintain and use this data because you are in public is simply false. This is data that is collected for speed violations, red light camera violations, and other violations that I've talked about. And we need to have specific rules on how long that data can be accessed, who can access it, and what it can be used for. So with that, I will turn it over to my technical expert, and then we also have Jeremy Scott on video. Thank you.
Hello once again. Chris Tippery, the Director of Automated Enforcement for Montgomery County Police, and I'm here to answer any questions that you may have about the process we use in Montgomery County as far as how we allow these images to be released or the data to be released or use that data in criminal proceedings.
Explain.
All right. Mr. Scott, you're up next. Welcome.
Thank you. There we go. Good morning, dear Chair Smith, Vice Chair Waldstreicher, and committee members. My name is Jeremy Scott, Senior Counsel at the Electronic Privacy Information Center, or simply EPIC. EPIC is a public interest research center established in 1994 to focus public attention on emerging privacy and civil liberty issues, and has long advocated for sensible limits on surveillance technology, particularly those that can reveal location information. I'm here today to testify in support of Senate Bill 381 regarding privacy protections for automated enforcement programs. This bill has a simple premise. Data from traffic enforcement cameras should be used for traffic safety and not be exploited for other unrelated purposes. SB 381 will be an effective protection for Marylanders' privacy because the bill requires 4 important concepts of data privacy: data minimization, purpose specification, data deletion, and auditing. Specifically, this bill protects Marylanders' privacy by requiring, to the extent possible, that cameras do not capture images of pedestrians or people in their cars, generally limiting access to and use of images and data derived from automated enforcement systems to only traffic enforcement purposes, imposing strong limits on how long that data can be stored, and ensuring that agencies comply with those requirements through an audit process. I want to stress how important bills like this are in today's society, because good governance includes limiting the use of data collected by the government to the purpose of its collection. We live in an age where more and more of the things we do on a daily basis can become data points to be collected and exploited. In the past, during a time where information had to be kept on paper files, good governance was protected in part by the resources, namely people power, it would require to use data for purposes beyond the original stated reason for its collection. Today, technology has not only increased our ability to collect data, it has cut the cost of collecting and analyzing that information. As more and more data is collected, there will be an ongoing temptation to use it beyond the specific reason for its collection. This is why legislation like Senate Bill 381 is so important. It will ensure good governance and provide confidence for Marylanders that the data collected for traffic enforcement will only be used for that purpose. Thank you for your time, and I would be happy to answer any questions.
Excellent. Thank you very much, Mr. Scott. I think we have a couple questions from the senators in the room. We'll start off with Senator Fulton, and then we'll go on to Senator Charles.
Thank you, Mr. Chair. If you want to step up and answer a couple questions about your all's policies. So who owns the rights to the videos and the cameras that that we're referencing in this?
We own them. The contractor stores them.
I'm sorry?
We own them. The contractor stores them for us.
Contractor stores them in the cloud or in their server, but
Correct.
You guys own the rights. Like the contractor can't go in and like pull this stuff. It's you guys that have the access to it.
Only at my request.
Correct.
And only from me, not from
And that's in the contract,
Yeah,
right?
there's nobody in my office.
So it has to come from you. All right. And then, is there, so what would happen if we had a crime that occurred, say it was a robbery, and there was an officer who conducted a traffic stop a couple days later, and then a few weeks after that, we realized, hey, that guy might have stopped that suspect, and he captured it on his body camera. Is there a process that we have to go and subpoena the body-worn camera footage?
I believe there is, but I'm only.
You have to subpoena your own body camera footage from within the department?
I'm not sure. I only deal with speed cameras, not body cameras. Speed cameras, yes.
Okay. All right. There's not. Like, it's the department's data. It's their stop. They can go and review it. It's a matter of public safety. And then, is there a process already in place in your department for an officer to sign out, say, something evidentiary value to go to court?
Of course.
And what is it? It's like a hand receipt, basically. They go in, they sign it out, they take custody of it. They say, hey, I requested this, I got it on this date. And then when they turn it back in or whatever, they'll sign it back in, right? Do they need a subpoena for that?
No.
It's not their property, though.
Correct.
So stuff that is Montgomery County's property by contract, you're suggesting that it's the proper way is to add in extra layers to require a subpoena and go in front of a judge and ask for that when realistically it's a part of the rules that would fall within the rules of evidence. If there was a request made, said, hey, I need this video or I need this camera from this intersection, we're looking for this suspect, wouldn't that fall in the same rules of evidence that we're releasing evidence currently now for court?
Sure, but as you know, we're the most contested and monitored and screened program out there. So we just put processes in place to ensure that we can ensure the public that the data that we capture is as secure as it can be.
So evidence that's signed out for a homicide, the weapon, got blood on it, clothes, all these things, critical elements to the conviction, has a process that is far less restrictive than what you're saying to get a picture of a car at an intersection at a given date and time.
But to the extent of that case, would I want that image to become in question on how I obtained the image of that offense?
Perfect. So that gets to my question. That gets to my point. So is it fair to say that you could have this same thing and not bog the courts down with subpoenas by putting an evidentiary process similar to the signing out of evidence to request the video and justification for that request that would meet the same requirements and justifications instead of a subpoena?
You can do a certificate of record. There's many different ways that you can do it.
That's perfect.
A preservation memo keeps you from deleting the information for a certain period of time.
Yeah.
I mean,
no, that's perfect.
There's all kinds of options.
Yeah, that's the exact point I wanted to make.
But nothing leaves our office.
A subpoena and asking a judge to do that is kind of over the top.
Subpoenas are, back in the day, it was a lot of work to get one. Today is pretty easy.
Okay. And then, is there any violation of law right now videoing in public without audio right now for anybody?
No.
Thank you.
Thank you, Mr. Chair. I have two questions. The first set of question is for school bus monitoring cameras, stop sign monitoring cameras, traffic control signal monitoring systems, the automated railroad grade crossing enforcement system. Are these camera systems recording 24/7 or only recording when something takes place?
The bus cameras are recording, and the data stored on the server or the computer inside of the bus for 30 days, and then it loops. That's the only system that we can go in live. I can peer through a red light camera. I can peer through a speed camera. I can actually go into a bus camera as long as the bus is running. Say there was a child abduction or assault on the side of the road. If we get the information fast enough, I can go live to that bus, rewind, and watch the video at that time.
And that goes to my second question. Child abduction, murder, bad accident, anything, robberies taking place. Like the senator, I don't want to live under a state of cameras recording everything, but when it comes to some major crimes like this, I believe that this information needs to be available to the proper authorities so that they can go in and pull the camera information. If there's a murder, if there's a homicide, I don't know if this bill is making it more difficult for law enforcement to get access to that information, because it should be fairly simple. If my daughter is being abducted, I don't want to wait 24 hours to get a judge to come in and tell me now we can finally get you access to this information. I don't know if this is the case or not, and you can explain it if that is or isn't, but I should be able to go and look and say, okay, this vehicle next to the school bus grabbed my child, and we should be able to go and after that particular
I can do
vehicle.
that live right now. I just need to know the school bus.
So what would this bill do to your current process right now?
The exigent circumstances would take place then. We would fall into that clause. And the only thing, the images that we get from speed cameras and red light cameras, unfortunately there was a shooting a couple days ago in Montgomery County. I have red light cameras there, and it actually takes about 3 days to pull that information. So it's not fast.
If I can follow up to the senator's question, this wouldn't change Montgomery County's process, and they're able to do that right now. And just to direct you to the section of the bill, on page 5, lines 12 through 18, so they can get it with a warrant, subpoena, or a court order. They can also get it in exigent circumstances without a warrant, court order, or subpoena. So in those cases that you're talking about, they can get it immediately.
Quick, so can I have a follow-up to that? And how long does it take to get a warrant? Do you know?
Chris?
Depending on what county, like he has 34 officers that work for him that can retrieve this data. Most municipalities or agencies don't have those resources, and there could be a delay in issuing the citation or the warrant, going and getting the judge to sign it, or finding the judge to sign it, and then getting it back. So they have a unique situation. I'm glad they have a unique situation, but that doesn't mean that every agency across the state that has cameras has that ability to do what they're doing.
I see one of my municipal chiefs here, and I know he has one of my smallest police departments in our jurisdiction. We got 27 municipalities in Prince George's County, and like if he doesn't have the amount of staff to work on something as fast as that, like if he's running into an issue with time for warrants, subpoenas, court orders, could you explain a little bit more in the exigent circumstances, I'm sorry, how that works in terms of this happens, immediately they can go to the school bus and say, hey, give me this camera information right now, need to get this?
Correct. And depending on the crime, we'll take the bus. We'll hold the entire bus for evidence.
Well, what about the cameras, like stoplight cameras? You know, you bypass, I didn't realize these cameras record 24/7. I thought it literally only captured footage of you running through the stop sign.
It only triggers the image when you violate the law.
What's that?
It only activates when you violate the law.
Oh, okay.
So if you go through it, you're not hitting the red light, your image is not captured.
Well, that's for the talking about the stop sign. The newer stop sign cameras now, where if you go through a stop sign, the camera itself captures you for going through the stop sign, not the red light camera. And so that stop sign, as people walking through the neighborhoods, people are riding their bikes, they're walking their kids, that stop sign camera is recording you 24/7.
I'm not sure. I don't have stop sign cameras. Maybe soon, but not now.
Okay. So yeah, I guess it does record 24/7, the stop sign camera. You may know better, Senator Love. I know that's your bailiwick. Yeah.
Those are new. Prince George's County is creating the only one we have in this state, so I don't have the answer.
Okay.
I hope they're not recording 24/7.
Yeah, I don't. I know there
It's a
are
lot of
cameras.
data. A lot of people.
If it's in a residential neighborhood and somebody has the Ring doorbell, that camera's recording, and it can be right next to the stop sign, but the stop sign may be recording. I want to make sure if it's a crime that's taking place, I know you said in exigent circumstances, whatever the case may be, I want to make sure it's simple, fast, and effective for our folks to be able to get the proper information and hold criminals accountable in our communities.
I understand that and I share that, and that's why I modeled it after Montgomery County, because they do it, I think, beautifully.
Okay. Thank you, Senator.
Thank you, Mr. Chairman. My question is for Mr. Scott. I wanted to bring you back into this conversation. Thank you for joining us, Mr. Scott. I share some of the concerns that were referenced by my colleagues here, but I just kind of wanted to level set on the Fourth Amendment, and, on the kind of the reason we talk about this issue in this way. It was kind of implied earlier that the Fourth Amendment analysis turns on the property interest. My understanding is that that's not the case. Fourth Amendment analysis turns on the expectation of privacy. And I just wanted you to kind of clarify how courts do Fourth Amendment analyses and how property interests play into that.
Sure. So the Fourth Amendment analysis done by courts is called a reasonable expectation of privacy analysis. And so they look at whether at the time, if you have a reasonable expectation of privacy, given the context of the situation. There's also a kind of a properly related privacy there, which would be, for example, someone intruding on a particular space of your property, your car, for instance. But in public, you have a reasonable expectation of privacy in certain situations. And traditionally, privacy has been protected in public by kind of the lack of technology to be able to record everything. So in Jones, for instance, there was a shadow majority that did support the idea that you have an expectation of your movements in public, because it's one thing to be seen in public at a given time, at a given date. It's another thing for your movements across time and locations to be collected and aggregated and then potentially analyzed at a later date. And this is where you really start to see some support in the courts for the idea that you do kind of have a expectation of privacy in your movements in public when you're talking about the aggregation of that data.
Just one follow-up, Mr. Scott. Just going back to property interests, like, for example, just because government has access to data doesn't mean another law enforcement agency within the same government is not required to get a warrant. So if I were cheating on my taxes, the federal government has access to those taxes at the IRS. The FBI is also part of the federal government. But just because that data is with the IRS, the FBI would still be required to get a warrant to access that data from another federal government agency.
That's correct, and that's part, now in the Fourth Amendment, just good governance, and this is kind of the idea behind the bill. Like, you look, this information is being collected for this purpose, it should be used for this purpose. If outside of that context, there needs to be some type of process that protects that data from just kind of use beyond the purpose. And there has to be a reason. That's why you have the warrant requirement backed by exigent circumstances. There was a case, and this is a little bit off kilter, but it shows the same example where regarding surveillance by the federal government under 702, which is a foreign intelligence, they collect information on U.S. persons incidentally. The court just ruled recently in New York that even though the government has that data collected for foreign intelligence purposes on U.S. persons, they have to get a warrant to access that data.
Oh, you don't have anything, Charles? All right, thank you. So I just want to, I'll continue on with Mr. Scott. Mr. Scott, the aggregation of the data that you referenced, you didn't say that it was for investigative purposes. You just said that the actual having it running and using it to track someone is a violation. But if it's being tracked for investigative purposes, they go back later because the person is said to be or thought to be a suspect in a crime. Does that violate the Fourth Amendment?
Could you clarify more? I mean, you're talking about the information here?
The aggregation, a person moving in public with criminal intent or a suspect of criminal intent and being tracked through that aggregation of data, does that violate the Fourth Amendment?
If you didn't get a warrant, it could, yes, violate the Fourth Amendment.
I'm sorry?
If you don't have a warrant, yes, that could violate the If you have a suspect that is, if you think there's a suspect that needs to be tracked and the police want to track them, then they need to get a Fourth Amendment to do that, to track them over time through the public.
If I'm tracking them through the public and other cameras, yes, I agree with you. I need a warrant for those other cameras. If they are cameras that are contractually the property of a police agency to, again, dispel bad information that was put out here, the IRS FBI analogy, those are two different federal agencies. They have two different roles within and functions within the government. Montgomery County Police and having a Montgomery County who houses the data, collects it, houses it, and being asked by an investigator from Montgomery County Police within the same agency, would the rules of evidence be violated if they signed that information out versus you're saying they need a warrant? I'm saying that's absolutely false.
In the context of information they already have within the same department.
Correct.
Right, that might be the case that they don't need a warrant for that. But this also bill goes beyond just, privacy in public. We're talking about good governance. When you're telling the public, hey, this is what we're doing, this is why we're collecting data, and then you're going to use it for something else, that's part of that's bad governance.
No. That's the intent of it, and everyone knows when they pass by them that it's being recorded, and they know, and it goes to the county. It is monitored by the county police. Therefore, like you said, there is no requirement to share that data with a warrant needed. You could do that through simple rules of evidence, which would be to make the request within your own department, and you could obtain that data.
Right, but that's the point of the bill, right? I mean, if a warrant was required, then you wouldn't have to have this bill right here, right? But the problem
we don't need this bill because we already have a process.
Under your analogy, if as technology becomes cheaper and they can put cameras everywhere, just blanketing all public spaces, then the police can have access 24/7 to all information about people, their movements, et cetera, without a warrant. And that seems counter to our democratic values. And so the point of this is to make sure that as technology advances and we're able to collect more data across the board, that we're protecting people's privacy and doing good governance in a way that aligns with our democratic values.
So what I'm hearing is there's no violation of the Fourth Amendment, which was alluded to. There's no violation in having a simple request through the simple processes that are already in place for evidence distribution within its own agency, and the scenarios given were not actually factual but made up. And what I'm telling you is what you're agreeing, we're being agreeable. The irony is the very thing you're asking for and being good stewards of all this evidentiary data is being requested by these certain big jurisdictions that want more of them. And I'm on your side. I want less. So I appreciate your candor. I appreciate your insight. Thank you.
Further questions from the committee? We're getting hot over cameras here today, all right? All right. All right, that'll conclude the testimony for the proponents of the bill. We're now going to hear from the opposition panel. We'll hear from, if Mr. Hamill will come on up. George Baccarin, Daniel Franklin, Andrew Bright.
Are we okay? Okay. Well, good morning, Chair Smith and Vice Chair Wallstrecker and members of this honorable committee. Thank you for having us here today. I'm Russ Hamill. I'm here representing the Maryland Chiefs and Sheriffs on this matter. We're respectfully requesting an unfavorable committee report for Senate Bill 381 at this time. I would be remiss, however, if I didn't note that we opposed this similar legislation last session, and we do appreciate the sponsor reaching out to our organizations in an effort to discuss our concerns and to reach a common ground. And as I am advised, the sponsor did accept several suggestions, but our organizations still have some apprehensions with the bill's current language. So we do appreciate that. We've already provided a memorandum to this committee outlining those concerns. I respectfully urge each of you to please read that. With our time limits, I'll be short. I only touch a few matters. First, requirements of the bill for law enforcement to obtain a search warrant, subpoena, or court order to access information already in its possession that the agency is responsible for properly managing seems like an undue burden upon law enforcement's ability to investigate crimes, thereby adversely affecting our communities and serving as a detriment to public safety. This also seems to be a potential further burden upon the limited judicial resources of our courts and state's attorney's offices. The allowance for permission to review the said data under exigent circumstances is also problematic, as that definition can vary. Simply, the vagary of such legal interpretation would likely result in further delays, regardless of the urgency or exigency of the matter, and even further burdening judicial resources. Finally, the issue we find most concerning here is the proposal for a rather quick destruction of this information, which may also be evidence in a criminal proceeding. I know most people observing this would think our biggest concern is that this may hinder a victim, a victim's family, or someone else, a loved one, from seeing someone responsible for a murder, sexual assault, human trafficking, and other horrible crime not being held accountable for their actions. That is critically important. But I'm going to tell you of equal concern is that this may lead to the destruction of critical evidence that could lead to the exoneration of someone accused of a crime. That brings us great trepidation, the idea that we would possess it, we would destroy it, and it could get somebody off from a crime they're accused of. So thank you for listening to us today. We appreciate the time. Have a good day. Go ahead, George. Me.
Good morning. I'm George Bakhorn. I'm also representing the Maryland Chiefs and Maryland Sheriffs. I would reiterate what Chief Hamill said, and of great concern is exonerating someone who did not do something, and we don't have that evidence available. That's a difficult conversation to have with a victim of a crime. And unfortunately, it would be us as law enforcement that would have to have that conversation. The other thing is, and that came to my mind while I was sitting here listening to testimony, is the purpose of these cameras. Yes, it is absolutely for traffic safety. But if you go by the idealization of traffic safety is public safety, and it has been for many, many years, what is the difference between a video image or a still image, a photograph, and the images and the data we collect on a daily basis through every city watch, town watch, whatever you want to call it, camera systems that we use to protect our citizens every day. And the last point I'll make is, again, there is precedence that public streets are public spaces without an expectation of privacy. We're not going into a car where you do have privacy. We're capturing images, capturing data on a public roadway traveled by the public in general. Thank you.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, members of the committee. I thank you for allowing me to present my position on the testimony. I am also here representing the Maryland Chiefs and Sheriffs Association. My name is Dan Franklin. I'm Chief of Police in the town of Morningside in Prince George's County. I'm here today testifying in strong opposition of Senate Bill 381. To key on something that was said by the sponsor of the bill, Senator Love, I would like to present a fourth bucket and call that the evidence to be used in criminal prosecution. I have one set of speed cameras in my jurisdiction in Morningside. Since May, that set of speed cameras has been responsible for solving 2 homicides by using captured data. I was able to access the captured data through my vendor in short order because they have that type of service for us. But in one case, it was a Hispanic gentleman that was gunned down in the street in broad daylight by 3 suspects in a carjacked vehicle. Because we were able to get the capture of that carjacked vehicle, we provided it to surrounding officers. Prince George's County Police was able to locate the vehicle, initiate a pursuit, stop, and arrest all 3 of the occupants. They are currently waiting trial. Another one is still under investigation, but I was also able to capture in much the same way at 1:30 in the morning from my house after consulting with the vendor. So to say that the process being proposed would be a little counterproductive, I think, is an understatement. We can run tags now on vehicles. All we have to do is key up the radio and ask. The information is provided to us. That information is what's provided out of data captures from our speed cameras. People have known to agree with Senator Love. Yes, they do say that we have a reduced expectation of privacy. People v. Weaver, 2009 New York case is the benchmark on that case. I'll close very quickly. We have seen significant advancements in technology for law enforcement. And many of those technology advancements came post 9/11, worst terrorist attack our country has ever endured. If this bill should pass in Maryland, I believe we're going to go backwards on that mission of using technology. We have a huge manpower crisis in law enforcement as a whole. The technology that's in use currently has been tremendously helpful in assisting us in solving and deterring crimes. For all these reasons, I'm asking the committee for an unfavorable report, and I thank you all for your time.
Good morning, Mr. Chairman and members of the committee. My name is Andrew Bright. I'm in-house counsel for the Washington County Sheriff's Office, and here today on behalf of the Maryland Sheriff's Association and Chiefs of Police Association. I don't want to repeat and just reiterate all the points that have been eloquently made. I would point out a couple of areas of agreement. My clients are very much in agreement that there should be no abuse of evidence. We don't want to see evidence destroyed, but we don't want to see it mishandled or applied inappropriately either, used for improper or non-legitimate law enforcement purposes. And so those kinds of infractions are already the subject of disciplinary proceedings against individuals who engage in them. And if those individual sanctions or punishments were increased, that certainly would not be out of line. The other area of agreement is that all of my clients have a respect for privacy of individuals. Unfortunately, once we walk out into the street, there are cameras everywhere, private and public, and one cannot expect to not be noticed or not be recorded out in public. The Supreme Court recognized the notion in a case that's cited in our memorandum, United States versus Knotts, back in 1983, which involved a radio tracker on a fellow who was manufacturing meth, and it tracked him all over town. These are much more less obvious than that. They track everybody who goes through an intersection, not targeting any individual. Thank you.
Thank you, Mr. Chair. Couple of questions based on various statements that were just made. Starting with you, Chief Hamill.
Yes, ma'am.
Did I hear you correctly to say that exigent circumstances is confusing?
Well,
So-
ma'am, I think what they did is they pulled down no less than 20 different definitions of it the courts used over the recent past. So our position on this will end up being just further litigation. Do we have exigency or we didn't have exigency? Does the officer even understand, by the way the law works, am I at exigency in this case? Am I not at exigency in this case? You know, we get search warrants in cases that we know we have under Carroll a right to search a car. But rather than have it go to that type of litigation, we freeze it, you get the search warrant. It can be confusing, especially for a younger workforce.
Interesting. Okay. Thank you. Then to Chief Bakewell.
Yes, ma'am.
Your comment at the end about City Watch and something else, camera systems that we use every
City Watch,
day.
Town Watch cameras.
Okay. Can you tell me, that sounds to me like there is an Overwatch surveillance system that's going on. Is that the case?
I think nearly every municipality, every city has some form of public street surveillance that they operate, that they own.
Is that authorized in our code?
It's not addressed in our code.
So you all are operating surveillance cameras in our cities, and it's not authorized in code?
On our public streets.
Interesting. Okay, thank you. And then my last question is for Mr. Bright. And I apologize, I didn't note down if you were a chief. I don't mean any disrespect.
I'm sorry. No, I'm an attorney.
Okay, great.
Represent Sheriff Brian Alberts.
Okay. I believe I heard you say that misuse of data is already the subject of investigations.
Has
Can you
been.
elaborate on that more? You currently have people that have misused data that's been collected and they're already subject to investigations?
Not data that's collected under surveillance cameras, but I'm aware of cases where, for example, an officer or a deputy would run somebody's tags for personal reasons, an ex-wife, a neighbor, somebody doing a favor for somebody parked and they were sanctioned for it, punished. That information is available to law enforcement, but it's not to just use willy-nilly as one sees fit. It's only for legitimate law enforcement purposes. If there's a investigation going on, it could be appropriate, but not for personal types of uses. And those misuses of information, data, it's a little bit different data than this, but not so different in kind, is punished. And people leave, they are fined for it, et cetera.
Is there anywhere in code where the misuse of this traffic cam data is constricted to legitimate law enforcement purpose?
Well, certainly in many departmental policies, and I'd venture to say maybe.
I'm not asking about policies, I'm asking
maybe
about
all of
code.
them, it's punishable. In the code, if it's misused, I'd have to research that. I don't know the answer to that.
Okay, thank you.
Surely.
Thank you, Mr. Chair.
Thank you. This is a question for any of you. What is the current length of time that you keep this information before it's destroyed? And I'm making an assumption at some point the data is destroyed. Is there a certain time frame? 3 years, 5 years, anything like that?
Senator, I don't know that off the top of my head. I can find that out for you. I believe it might be subject to the contractual agreements with each vendor the departments have.
There's nothing statewide where statute of limitations is three years for civil type stuff. And I would assume that there's no need to keep this type of information, especially if it's a thing of solving a murder or something like that.
Again, we can research that for you and find out what the different, if there are different parameters.
Okay. But if I'm hearing you all, what I'm hearing in terms of most problematic about this bill, I'm thinking is on page 5, lines 27 through 29, which says an agency shall immediately remove from its record and destroy any recorded image or associated data captured. And then on top of on page 6, lines 2 through 5, just giving you about 6 months to essentially see whether or not there's information of any other type of criminal conduct that you all need. And that's too short of a period of time, is what you all are saying. Am I correct?
Yes. Sir, quite honestly, I was having trouble hearing you, so I'm reading it instead. That's on me, not you, I think.
No.
I was looking at the picture of this elderly man sitting here next to the chief, and I realized it was me. So.
I'll try to speak up.
No, it's okay. So I read it. I think the question is, yes, we do believe that 6 months is too restrictive of a time.
With your agency, and I know you said it's contractually, are you aware of how long you can keep the records?
Now, off the top of my head, I can find that out.
Okay. Look, thank you.
Thank you.
Chief, you can stay up here. Thank you, Mr. Chair. So part of the issue is, and I hear what my colleagues are saying, storage of this data is expensive.
Yes, sir.
And if the data is relative to a crime, there is no, especially like a felonious crime, it's an indefinite storage, right? Like if you've already linked it to a crime and you captured it, the storage becomes indefinite.
I would say unless we receive an order to destroy it.
Sure.
Yes.
After the trial's adjudicated and there's no further appeals and all this other, but if it's a part of a crime, it does become indefinite.
Yes,
Is that, okay.
I would believe so.
And then the violation that was mentioned earlier, when all law enforcement take their meters and their MVA login and are they not educated about the rules and responsibilities of handling such privileged data?
So, sir, I think, as you know, I came from a rather large police department before I came here. And yes, we did have incidents, as the chief mentioned. We have, especially today, with police reform, we have robust disciplinary processes in place that are designed to handle these types of issues.
Well, my point is, Chief, is if someone logs into their computer, their MDT, and they run a tag, is it marked, is it a tracking point through their system that logged in user utilized that data to extract or make that request through NCIC, through meters, through MVA, whatever it is?
Yes, sir. We can even track when they ask the dispatcher to do it. We can track back who asked.
So there is a process in place that kind of codify and make sure that, as best we can, that it's being safeguarded. And if there is violations of it for personal use, and it clearly says in every training I ever went to, any misuse of this data for personal use, anything other than a law enforcement purpose is a violation and subject to up to termination.
Up to termination, yes, sir.
Yes.
Yes, sir. I'm pretty hard about that.
Yes, thank you.
I take a pretty strong stance. Yes, sir.
I have I know what else. I just want, somebody mentioned the Carroll Doctrine. I just want to make sure we put it on the record that, so everybody understands that's watching at home, the Carroll Doctrine, the Supreme Court decision that law enforcement may search a vehicle under exigent circumstances, but what the problem we were running up against is that it allows us the exception of the Fourth Amendment. However, there's a lot of variables in the exigent circumstances on interpretive measures by judges. Is that fair to say?
I think that is fair to say.
So there's a lot of definitions of exigent circumstances currently in law.
Yes, sir.
Okay. And then the other thing I wanted to touch base with, I saw that there's a letter from the state police, a letter of information, and it says that this bill requires an agency to immediately remove from its records and destroy any recorded image or associated data captured under the automated program that does not constitute an evidence violation. Is that accurate?
I think we'd have to ask the sponsor.
Yeah, that's fine. Well, okay, I'll do this. So last year, we passed a very robust opportunity to ensure that our highway workers are safe.
Yes.
Okay, and we put a lot of that. And the state police letter also references that this bill would undo what that bill had accomplished because we could only retain certain images for up to 6 months. Even if there were, so the images can only be used for traffic enforcement, thereby restricting a valid means by law enforcement to identify vehicles used in crimes and other related offenses. Does that seem problematic for you as a police chief, that we can only use it for traffic
This committee's
purposes?
heard me talk about a particular case where it gives me pause, gives me great concern.
And in closing, Chief, I guess what I'll ask you is there, we've kind of covered where the information could be misused, but is there any, when you go to your community members, are there any community members asking you all to do less policing, less enforcement on traffic, less, being able to keep their community safe through the means that are contractually your property?
Sir, I'm actually getting it from the other side, that we need more policing. We need to solve crimes. While I was sitting here, I got an email from an angry constituent about just traffic enforcement on their street, a residential street.
Yeah.
So the pendulum's kind of swung where they expect.
Yeah, I just want to make sure that I'm not
enforcement services.
encouraging
They're not
more
asking us.
automated enforcement in residential areas. Just want to make sure but thank you, Chief.
Thank you. Thank you, Chair.
Thank you very much. All right, further questions from the committee? All right, thank you all very much. With that, that looks like that'll end the hearing for Senate Bill 382. We'll now move on to our final two bills, 390 and 391, both of which are mine, so if the Vice Chair can take the seat.
Can you give us some
All right, let's see. It's not a cop joke, is it? No. That's a good one. That's a good one. That's a good one.
Yeah, that one was pretty good.
All right. Good afternoon, everyone. Senator Smith here to present Senate Bill 390. We've actually heard this bill, but it was not sponsored in the Senate, so we're going to have a full panel. This came over from the House, but we just didn't have an opportunity to move on from it last session, and because it got over here pretty late. We've heard a lot about how we've needed our law enforcement officers to do more and more and more. That was kind of the theme of the last bill. But we also know that we have less and less and less. I asked our friends at MACO and MML, how many law enforcement agencies are there? So there are 150 law enforcement departments throughout the state of Maryland and about 18,000 law enforcement officers today. But if you look through our largest jurisdictions, like so for Montgomery County, we have 166 vacancies, which is a 13% vacancy rate. In Baltimore City, we have a 24% vacancy rate, which is 619 officers short in Baltimore City. Baltimore County has 235 vacancies. That's a 12% vacancy rate. Anne Arundel County, a 5% vacancy rate. Prince George's, 19% vacancy rate, and I could go on. That's a theme all throughout, and I know the mayor of Frederick is here as well. He can attest to this for his own jurisdiction. And so we're asking law enforcement to do more, but we have less. And so what this bill does is it, currently, right now, for those traffic lights, to review cameras and to approve those citations, only sworn officers can do that right now. And so what this bill does is it says that a technician, a qualified technician, can also assist in that endeavor, therefore leaving the officers that are currently assigned to this duty to go out and do other important law enforcement duties, things that we all know and need them to do throughout the course of their work. It also incorporates a new training requirement. Today, again, the only requirement to issue these citations is that you have to be a sworn officer. On page 2 of the bill, if you go through lines 31 through 34, now you'll have to have a little bit more training, or training at all. some training. So now you have a force multiplier that allows our law enforcement officers to go out and do that law enforcement work, plus you'll have a raised standard for training. This is also important because I want to give Abigail, or Abby Bento, some credit on this because she did some work on this bill in preparing me for this hearing. And she looked at the MPTSC's annual report, and she found that over 25,000 erroneous citations were reported in 2024, which if we have increased our fines from about 40 to 80, so they've gone up a little bit. And she said that if the minimum fine was $80 and over 24,000 citations were erroneous, that would be a minimum of $1.9 million, so $2 million of wrongfully existing citations that were issued. So the point is this: we have a dearth of law enforcement officers out there in the field. The current system is issuing a lot of false positives, and there's no training requirement. So what this bill does is, I think, provide for a more efficient use of our law enforcement assets and resources. It provides for more training. With that, I would ask for a favorable report. I'll stand by to take questions at the end of our panel. And I believe that's it. I think it's pretty much, that's the sum and substance of the bill. All right. Mr. Mayor.
Good afternoon, members of the committee. My name is Michael O'Connor. I am the president of the Maryland Municipal League this year and the mayor of the city of Frederick. We appreciate your consideration of Senate Bill 390 and appreciate the senator's sponsorship of this legislation. Current law allows for non-sworn personnel to review red light camera citations. And so really what we're asking for is some consistency in the area of automated enforcement to allow, as the senator has said, the best deployment of those uniform resources where we need them. Our agency is an agency of 157 authorized. We are down 10 officers right now, so not quite the vacancy rate that some of those other departments are experiencing, but the concerns that we hear from our residents, which you've heard from some of the other prior testimony and bills, is that the demands on our law enforcement community only increases. Speeding is the #1 concern and complaint I hear from residents in every neighborhood in my community. And even with a authorized force of 157 to cover 22 square miles in the city of Frederick, I could not place a police officer in every place where there are concerns about speeding. This is why the automated enforcement is so valuable, because it is that force multiplier. We have a part-time technician that reviews our automated enforcement on the red light camera side. We'd like to be able to turn that into a full-time position to look at all of the automated enforcement, because we think it's the most efficient use of the highly trained police resources that we have. Yes, training is important, but the kind of training necessary to review these citations is not the kind of training that we put police officers through in the academy. And we believe that there is a better use of the dollars than paying police officers to review the citations that we get. We are presently in an arrangement with the town of Newmarket, a community that does not have a police agency. And they would like to be able to deploy this resource, but cannot, because they don't have uniformed personnel to review those, so they contract with the city of Frederick to do that on their behalf. We want this tool to be available for every municipal government across the state of Maryland. Thank you very much for your time.
Good afternoon. Bill Jorsch with the Maryland Municipal League here today in support of Senate Bill 390. A lot of my points have been touched on by the chair and the bill sponsor and the mayor of Frederick so far. So I will touch a little bit on why MML and our 157 municipalities are interested in this bill. 88 of the 157 have a police department. And as mentioned, allowing a technician to review speed camera images and issue the citations would provide personnel flexibility that's much needed with the shortages that have been discussed. Secondly, and the mayor touched on this at the end of his presentation, is that the other 69 municipalities do not have a police agency. Currently, we know of only 3 of those municipalities that are operating speed cameras, and they do so in a contract with either their county sheriff's office or a neighboring municipality with a police department. And anecdotally, we're hearing that this is providing a bit of a barrier to entry for some of these smaller municipalities. Now, I think the fiscal note touches on this in that the bill really provides operational flexibility, but this is not going to lead to a large proliferation of speed cameras popping up. Those that currently don't operate programs are the smaller ones that may, if they so choose to do this now by able to employ a technician. These are not large jurisdictions, and the number of cameras that would be deployed in their jurisdictions is likely very low. That being said, they're essentially kind of boxed out at the moment from even making that choice, because finding a benevolent police agency nearby to take on additional work is proving very difficult. In your packets, you should see supporting letters from the Prince George's County Municipal Association, representing all 27 municipalities in Prince George's County, almost all of which have a police agency, as well as small towns like Glen Echo and Montgomery County that does not have a police agency, but may be able to utilize the technology to keep their residents safe should they have the provision to use a technician. Urge a favorable report. Thank you for your time. Happy to answer any questions.
Thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here from the Maryland Association of Counties, and we are here in support of Senate Bill 390. This is authorizing legislation that we can use as we see fit, so it's not mandating. We do think that it will help us get and keep police officers in our communities where their expertise is needed to make sure that our community members and residents are safe. We think that's a good thing because we do have a shortage right now of officers. And we also like that the bill specifies that this is a trained individual, and we think that'll make sure that they understand the technology, but also the adjudication process for citations like this. So we think this is a good governance bill. It gives us flexibility to use this if we see fit, and we would certainly support Senate Bill 390 and urge a favorable report. Thank you.
Good morning again. Russ Hamill. I'm here today now representing MML as well as Maryland Chiefs and Sheriffs in support of Senate Bill 390. The chair already brought up most of our points, but I do want to touch on a couple. We're requesting a favorable report because we believe this bill would permit law enforcement agencies with these programs to have the civilian technicians review the recorded images of alleged violations produced by the cameras and swear or affirm to the recorded violations' accuracy rather than require a sworn law enforcement officer to do so, as is currently required in my jurisdiction. I use a sergeant for this at this time. The legislation would free our sworn personnel from these duties, allowing them to be assigned to tasks required of sworn officers rather than these administrative duties. This is especially critical right now with us struggling with recruiting and retention still to this day. It simply serves as a force multiplier and to make sure that we're enhancing our community safety by having our officers out doing what they're trained to do and what they're responsible for doing, and having us the ability to use a civilian technician to do this. Our non-sworn staff currently does the red light automated enforcement citation program. They've been able to do that since 1997. We believe that's handled professionally as well. I don't think we lose any professionalism moving this over to that committed staff. I think this simply is a good public policy to allow us to do this. I don't anticipate it causing any great training issues. Currently, our vendor trains our people. Our sergeant was trained by our vendor in doing it. And my sergeant assured me that it would be easy to have somebody else trained to do it that's not sworn. So we respectfully request a favorable report on the bill, and thank you for your time again.
Thank you. And I do recall this bill from last year. I think it was relatively supportive of it, but I just want to understand something. So given the chairman's reference to, was it 24,000 erroneous tickets or 2,400? Oh, big number. 25. That just made me think about the fact that, and that's with law enforcement, right? The only group that can deal with these citations. So I guess I'm saying, what skills are needed and to do this, and how will we ensure that, you know, adequate training is provided? And I guess these erroneous citations might be something to do with keeping the equipment, I could be wrong, but the equipment correctly calibrated to not issue erroneous tickets? So I just don't want to exacerbate the problem, and just hear about some assurances of how taking it, you know, expanding it in light of the erroneous ticket problem already. How do we just ensure that we won't make the problem worse?
We have a resident expert talking about what they do in
Yeah,
Montgomery
yeah,
County, but
yeah.
at least this codifies the standard of some training, which is
Right, but-
not there now, but you can give us more elements of what the exact.
Do you happen to know why there's that many? Is it the calibration of the machines that is generally
I
causing?
don't know the answer to that question,
You
but I
know?
can give you a copy of the report.
Yeah,
You can
just-
little-
I'm all for, I think I supported it last year, I'm supporting it
Yeah, yeah,
now.
yeah.
I'm just trying to make sure we have the right, make sure we ensure good training, and especially if it has anything to do with keeping that equipment, sharp, if you will. and
What I'm
accurate.
advised by some subject matter experts is that this is probably more to operator error. Certain things like a Virginia vanity tag, which a lot of vanity tags there
Right.
being misread.
By the person, by a human or?
By the
a
human
machine?
looking at it. So yesterday I actually sat with my sergeant that does this, and he showed me how to do it. He actually said, if you have any technology savvy, you could do this. Honestly, he then said, that's not you, chief. But anyway, he did it in front of me. And it looked to me, once you're trained, very manageable. They make sure there's a violation. They make sure the tag matches up to on both pictures. They make sure that the listing of the car matches up to the car they're looking at there. But I could see where errors would occur there, just somebody not realizing a certain make of car, like the GM Chevy question, which is a GM, which is a Chevy, somebody messing that up. It looks like it might be in some of the larger jurisdiction, a pretty low error rate.
So is there a way, I don't want to over-legislate or micromanage, but is there a way in this bill, if we're going to expand it, to ensure that training is enhanced? Because it just seems like maybe that's not a large error rate, maybe that because it's millions and millions of citations, it's a de minimis amount, but I don't know how to put that number in context. But I'm just trying to make sure that if we expand the program, we also ensure we're hopefully bringing down the error rate or not increasing the error rate.
I would hope that would occur as well. I think by being trained by the what I absolutely don't want, maybe you guys don't care about this, I know, but I don't want the vendors doing this. I think this does belong as a law enforcement function, so I wouldn't want to see the bill go that way.
Right.
But I think they can provide the proper training, and the training may need to be a little more robust than to get this. And I can't tell you what every vendor does with training. I know what our vendor does, and our folks say it's pretty good.
So I'm not going to suggest any amendment, but you wouldn't be opposed if we happen to just clarify the language to make sure it's law enforcement that are training the expanded employees, because that's what you would prefer anyway?
Our vendor trains our folks. I think that's important to have
You
the
think
vendor
that's
do
the
it.
better
The
form?
subject matter experts, yes.
Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chair. Whoever wants to come up, but who trains, so you're talking about training. So they're training them on the use of this system. Are they training them in the theories and concepts of radar and LiDAR? Who's training them in that?
Senator, that I don't know if they're being trained. I know.
As a police
in my case,
officer.
my sergeant does. My sergeant that does
Correct.
this is in charge of that program.
He's in charge of traffic, and he's been trained in speed detection. And so I guess, and the standards of conduct for a police officer who would inappropriate, we were just talking about misuse of information and data. What is the recourse for a sworn officer who handles this inappropriate or misconduct versus that of a civilian?
For me, there is no difference between
There's no
that.
difference? They have the same standard?
I would have the same standards for that. Now, it would have to be something nefarious. If they just make an honest mistake, we're human. We hire from the human race. That's
Sure.
going to happen. But
I'm talking about if they
intentionally doing something. It's their
correct
ex-husbands, and so they're okay. We would take that very seriously.
But it's also, a document that they're signing, a sworn attestation.
Yeah.
And so it's a misdemeanor, 10 years for perjury, and that's what perjury is. So if they falsify those documents intentionally, that's a 10-year misdemeanor.
Okay, thank you. And then that brings me to my next question. Testimony in court. If someone appeals the process, appeals the citation, an officer is trained for, I think, like some ridiculous amount of time, 2 or 3 weeks, just on radar, LiDAR, and how it works and the concepts therein. You have to be able to train it. You have to be able to explain it. And they're using these cameras, and they're being deployed by the contractor. So this is like a collaborative effort here, and I don't see anything in there that basically touches on the required, expertise for court testimony.
You can answer too, but it's also in the statute.
Thank you, Senator. I think, as you may know, the civilian that does this work on behalf of the Frederick Police Department does all of the testimony in court for both red light and speed cameras, according to our department. So
you guys currently do this?
The civilian who is doing the reviews in the city has the ability to testify on behalf of these citations in the city of Frederick.
But you just said currently you have a civilian doing red light and speed enforcement cameras?
Red light cameras, and my understanding from my department is that that individual is also able to testify on behalf of the speed cameras as well.
That's not in the statute right now. That's what we're discussing right now. How is that possible?
I'm only providing the information provided by my department.
So you're telling me, Mr. Mayor, that your agency of Frederick Police is violating statute right now?
I'm not saying that.
Okay. You just did say it.
I'm telling you what I've been told by my department. We can certainly get clarification on that point.
Yeah, I think we need to, because that's a serious issue. Yep, thank you, Mr. Chair. I'm good.
All right. Senator Sidnor has no questions. Mr. Chairman, anything additional? Okay. Seeing no further questions for this panel, thank you so much.
Hey, thanks a lot.
Wait 1 second. I think we might have one more witness on this. George Acorn? Acorn?
What did the kid on the speech say on a very high day?
I think we still have another witness on this bill.
What? What?
Yes, how did you know?
Mr. Bacorn, did you want to testify?
If you're good, I'm good.
I'm good, yeah. It's up to you. Thanks, sir.
Take care.
Thanks.
Okay. It looks like we're moving on to the next one, Mr.
Yeah,
Chairman.
it looks like, I think that's right. Yes, please. This will be
right.
quick.
So just for the record, as committee manager is doing that, completes the hearing for Senate Bill 390. Next is Senate Bill 391 with the chairman and committee managers bringing up some technology here.
This will be really quick, but I wanted to pull up the password.
I got it. You want another picture, let me know. That's nice. I guess not.
Did you hear about the guy?
All right, go ahead, Mr. Chairman. Thank you so much.
Thanks. All right. For the record, Senator Smith here to present Senate Bill 391. So during police reform and in subsequent years, we created an entity within the department or the Office of the Attorney General to do independent investigations of officer-involved deaths in Maryland, and we then subsequently added the ability to prosecute. So setting aside what you think of that policy, the bills also required the Office of the Attorney General to create an accessible, publicly facing website. And to my mind, I think this is exactly how government should operate, because you can get the video, you can get the transcripts, the full report, the statistics. And while this initial bill was used to capture these officer-involved deaths, there's a lot of other information, or a lot of other very important information you can glean from this data set when it's disaggregated. So you can find out, is there a particular part of the state that has more of these incidents? Or is there a neighborhood that's having more of these incidents? Is there, are there more people of a certain demographic that have been impacted by this? So you can glean a lot of other information from this report that can then be used to make other policy decisions. For instance, are there more officer-involved deaths that are involving police chases or firearms? What scenarios are there? So there's a lot of stuff you can glean here. And so what this bill does is it simply says that the information and the reports that are published annually from the Office of the Attorney General, the Maryland Police Training Standards Commission has to just look at that information and make recommendations on how to improve policing. That's all it does. I worked with the Office of the Attorney General and I worked with MPTSC with this bill, and they're both fine with this. They're both supportive of this. It's a very simple bill. I think it will ultimately improve relations between our law enforcement officers and the communities that they serve. And it'll provide and keep providing for a more transparent ecosystem for our law enforcement agencies. So with that, I'll ask the committee for a favorable report and stand for questions.
Just wanted to say I like the idea. Many times we ask for data to be collected and it's sent somewhere and nobody ever looks at it.
That's right.
You're forcing them to look at it, and if they see a problem, forcing them to come up with a solution, which is, I guess, essentially what I was attempting to do the other day with our driving while black, or the pretextual legislation, which is saying, look, the data's here. What's the solution?
What's the solution?
I love this idea.
No, I actually like. I like I like this with the prosecutorial, like the tracking system for the database, the case management system. I think that's also something that I'm looking to put more energy into this session, but it's along the same lines of that as well. Hey, it was good. Hey.
Thank you, Mr. Chairman. That completes the hearing for Senate Bill 391. Do you want to give us some instructions as to what's happening next?
Sure. So we are going to take a 10-minute break, and then we're going to jump right into our voting session. I think we have 9 bills on the docket. So just 10-minute break so the system can reset, and then we'll come right back for voting.